Call the September meeting of the Rules and City Government Committee to order. Please note for the record that Alderman Arnett and Alderman Savage are in attendance. We also have Gary Elson, our Assistant City Attorney, and Pete Gutwald, Director of Planning and Zoning, and Alex Zaknovich, who is the, what's your title now, Alex? Chief Operating Officer. Okay, from Anne Arundel County Public Schools. Thank you. I'll entertain a motion to approve the minutes from the July 16th meeting.
So moved. So moved. Second.
Okay, all in favor?
Aye.
Any discussion?
No.
Amendments, corrections? All in favor, please say aye.
Aye.
Okay, minutes have been approved. Okay, first item on our agenda is 0818, adequate public facilities, adequate school facilities, standards for the purpose of amending the test for additional school capacity by requiring schools with enrollment greater than 95% of the state-rated capacity to be listed as closed on the annual school utilization chart and matters generally relating to adequate school facilities. And Mr. Zaknovich, you are our resident expert today. Your mic, could you make sure that it's turned on? Press the button under where it says push.
Good.
This legislation, as you just heard, will change the standard, which is currently at 95%.
No, it's currently at 100 for elementary and middle.
Okay, what's the, wait a minute.
It's currently at 105 for...
Well, why don't you tell us what it is currently?
Oh, you mean in the county?
Yeah, that's
oh,
where.
Oh, I thought you were talking about city.
I thought you were talking about what our legislature.
Mr. Zaknovich represents the Board of Ed,
Right.
and this is their business. Okay, so Alex, would you mind telling us what the standard is now and how this legislation would impact you?
And specifically, you're asking what the city standard is, not the county government's, correct?
Well, no, we want to know what the county standard is.
Okay.
Because the county was going to change it to 95.
They have. So the county recently adopted a piece of legislation that closes elementary schools at 95% of the capacity, middle schools at 95% of capacity, and high schools at 100%. It initially started out as 95, 95, 95, but through an amendment, it was amended to be 100% for high schools, 95 for middle, 95 for elementary. That is the ordinance, that is the APFO ordinance that's currently in place for the county.
Now, can you tell me what it was before the change?
It was 100, 100, and 100.
Okay. So we've reduced the standard in elementary and middle schools down to 95%, and it's maintained at 100 for the high school.
That's correct.
Okay, and that's county-wide standard now?
Correct.
Okay.
And if we made those changes, we would be consistent
In
with the county.
compliance with the county.
Well, is there a... I think at one point they were talking about having a sunset to this. Is there a...
Yes, there is. There's a sunset provision in it that it would, the county is currently working on their general development plan, their 10-year GDP, and the provision would sunset either at the end of 2019 or upon the adoption by the council of the new GDP.
And so, if it sunsets next year, so it's only for a year, are you all already working on a new set of standards? Or do you have any idea what your preference would be?
Well, the way that the ordinance is written, when it sunsets from 95, 95, 100, it goes back to 100, 100, 100 automatically. So that's essentially the way the ordinance was written. I think the purpose of the sunset is to allow two things, is to allow for ongoing dialogue between the administration, the school board, and other constituencies, such as the developer community, et cetera. And secondly, is to allow the general development plan based on what the anticipated future growth is gonna be largely driven by the underpinning zoning of the properties, and to allow us to better understand how the land in the county is gonna be used between 2020 and 2029, and that would essentially allow all of us collectively to recalibrate the APFO law at that time.
So let me understand this. So during the during the creation of this new plan, are you all planning new schools to accommodate new growth that may appear in the GDP?
Right. So yes, we annually submit an annual CIP, which is our 1-year request, and then we submit our 6-year plan, which is required by state law. So we have an annual budget and a 6-year capital budget by state law. We have a master plan that we create. Also, the last master plan we had was published in 2015. Done for us by an external consultant, MGT of America. It's our Strategic Facility Utilization Master Plan. And that basically has a 10-year planning horizon in that document. Now, of course, in order to publish a document in year 10, you pretty much have to start working on it in year 8. So we've recently published that, and that is, the GDP is a big element in understanding what future growth and development is going to be. So we're living under the current MGT study. We're living under the current capital budgeting environment. We are, in fact, the board will take up its capital budget request tomorrow at 10 a.m. When it convenes. We'll have a work session on Thursday, and then 2 weeks from then we'll adopt it. But we do anticipate several new schools in the capital budget, and new schools are to accommodate the growth of our overall population. We are a growing county. We're one of the fastest growing counties on a percentage basis within the state of Maryland. A portion of that growth is, in fact, obviously tied to growth and development, but also we have folks moving in, and we have folks like me potentially that no longer has children moving out, and then that house is backfilled with a younger family with children. So there's a lot of dynamics, but our forecast for Anne Arundel County, this may actually be of interest to the council members, to the aldermen, I'm sorry, is, let me, hang on a second. So 10 years ago in 2008, we had our certified actual enrollment, 2008, was 73,658. 73,658 was our actual certified enrollment. This past year, September 30th of 2017, our actual certified enrollment was 82,777. So we essentially almost grew 10,000 kids in 10 years. We are anticipating 10 years from now, in 2017, our projections show that we'll have 95,458 children. So we are going to pick up, we've picked up 10,000 over the past decade. We anticipate picking up yet another 10,000 youngsters in the decade ahead. So our capital improvement plan is both expanding existing buildings by additions, targeted additions. So if the building is in good shape, but it simply has a capacity issue, we'll put a small addition, a 4-room, 6-room, et cetera addition. If the building is essentially past a certain point in life that the building itself needs to be comprehensively renovated and or replaced, we will renovate or replace the building, but it will be replaced with a larger building. That's the second way we address capacity. The third way is we build a ground-up school. We take a piece of vacant land, we stand up a school where one never existed before. That also creates capacity. So those are the 3 possible solution sets inside of the capital budgeting process.
I guess the $64,000 question is how you fund it. Are you capable, for example, in the last 10 years we've grown by 10,000 kids.
Right.
Has your development kept up with the increase in the student population?
No.
Okay. And so And you expect, I assume, the same thing to be the problem going forward?
Well, to some extent, I mean, there's constraint on capital debt affordability. That constraint exists at the county level and at the state level. Both units of government basically have capital debt affordability models that say as a percentage of our gross revenue, of our land holdings, so they have a couple different algorithms, but the county and the state both have a AAA, essentially bond rating, the top rating from the agencies, and they're, to date, the decision makers at the state and county level are wanting to maintain that, preferred highest credit rating, because the better your credit rating, the lower your interest costs, right? The better term and conditions you can get on any borrowing. So by trying to keep to that AAA credit rating and not wanting to stretch and go further into debt, essentially, that's putting a constraint on the total amount of dollars that are put forward for construction, period. Schools are a part of that. Now, you spoke about the last decade, Alderman Finlayson, and obviously, everybody had a great plan on what we were going to do, but, 2007, 2008, 2009, so when we went through the very large, global economic recession, that did curtail a lot of the capital expenditures that all of us, including the state and the county, had planned to do. So we're a little bit behind where we anticipated we were going to be, but nobody foresaw that we were going to go through 5 or 6, years of economic malaise.
Can I ask the
Yeah, Alderman.
$32,000 question, which is, are our schools included in Annapolis in your plan?
Absolutely.
Okay. Good.
Absolutely.
Good. So the follow-on then, and I'm asking this because I'm thinking about it right now, is wouldn't it be smart for us to just be consistent with the county thresholds? So we can do 95, 95, 100. And we could even put some kind of adjuster if the county, right now, we wouldn't want to revert back to where we are in the code now, but I could certainly see adding a clause saying we would revert back to 100, 100, and 100. My goal is to be consistent with the county and certainly be more stringent than we are right now.
Well, and to take it a step further, the county has a sunset, in which case, at the end of that sunset, it reverts back to
That's
the
what I was just
original,
saying.
or there will be other standards set.
Correct.
So I would be comfortable using the exact same standard to say that we'll let it sunset in 2019, and we'll revisit it as the county sets their new standard, or we'll go back to 100, 100, 100.
Yeah.
Can I add just one point of personal privilege? This APFO adjustment that we recently completed, County Executive Shu had a multidisciplined team, public and private sector. There were developers, et cetera, that met for a number of sessions, about 3 months to arrive at this new agreement, and Councilman Trumbauer, who obviously represents the city, was one of the 2 council members on the panel. The other council chair, Peruka, served on the panel, and then Councilman Trumbauer was deeply involved. But the point is that I think we arrived at these compromises successfully, unlike prior attempts, because it really was a collaborative effort. There were actually more developers on this committee, task group we called it. There were more developers on a task group than there actually were public sector employees, interestingly enough. And I think because they felt that they had a seat at the table and participated fully in the dialogue, that we sort of arrived at a place where we could all live for a period of time until this entire GDP process cleans up. That's one piece. The second piece that was still in flux was that the state had what's called the NOT Commission, the 21st Century School Commission, that the state studied the amount of spending that it is doing on public schools and determined that the amount of capital investments into public schools is insufficient. The state did a large study a long time ago. They never cost indexed the amount of money that they were putting into it, so the time value of money had eroded, and their old $250 million floor didn't have the buying power of $250 million anymore. So the commission did recommend that they increase the new funding floor to $400 million a year instead of $250 million. That is going to go to the General Assembly this time, but the governor's behind it, the two presiding officers are behind it, the comptroller and the state treasurer behind it. So I think with that, there is a renewed commitment to capital spending on schools at the state level. And then the second piece is last winter, the county executive in Anne Arundel County put forward a piece of legislation that allowed Anne Arundel County to sell a bond of a longer duration than we previously could. The state of Maryland can only sell a 15-year bond. That's it. Anne Arundel County's code set the duration as 20 years. But when you're talking about a school, you're talking about an asset that has at least a 40, and in our case, in reality, a 50 or 60-year lifespan at least. So the county executive put forward legislation, and it did pass, to extend Anne Arundel County's bond duration from about 20 years to 30 years. Doing that expansion from a 20-year bond to a 30-year bond generated about $25 million more a year of CapEx, of capital dollars that can be applied. So what I'm saying that to say is that I think both the state and the county know that they have to address this problem. We know what the growing enrollment issues are, and I think with the new funding from the state and the new funding from the county, I think we'll be able to at least make further inroads to start eradicating some of the seat deficits that we have.
Alderman Savage.
Thank you, Madam Chair. So I did have another question about the counties, what standard they used. The minimum unit threshold, in terms of when this kicks in terms of which type of development it freezes. I thought the county used to be 4 units. I think the city is 11 units
11.
or larger.
Right.
What did the county end up going with?
So the county was 3, and they've
3.
raised it to 5.
Okay.
So we're still more flexible than the county. So going back to the point, I like the idea, particularly given what Alex said about the panel with developers on it, they got their input, they were comfortable. I like the idea of being consistent with the county, and rather than have our sunset, maybe, and we'll have to talk to our lawyer about this, have a clause in here that if the county changes its standards, like it reverts back to 100 and 100, that would be cause to reopen the legislation to reevaluate our standard. Or failing that, in fact, what I really think might be a good idea is to just say in here that our standards will be consistent with the county standards. I think that's a lot simpler, and that's really what I think people want.
That's what I'd like to ask Gary, Mr. Elson.
Yeah.
As opposed to us revisiting this after the county does, can we just say that we will follow the standards set by the county?
I think so. You don't have to go back into the legislation at that point. So it is more simplified that way.
So would we, on page 2, would we change C? It says notwithstanding the definition, blah, 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 and then it enumerates elementary and middle school, and then high school. Could we just have a statement that the city's, what's our term of art? Capacity thresholds are consistent with the county's thresholds for elementary, middle, and high
I mean,
school.
instead of actually putting in the percentage,
Right.
you say in other words, we can take out the percentage and just put in that our percentages would correspond to the county you know, what the
Mhm.
county does, and, I mean, if you're not satisfied with what the county does at some point, then,
You can always revisit.
then you'd have to come back into it. you
Right.
know.
Well, what about the minimum unit threshold?
Well, I
I-
think we need to talk
I
about
don't know
that. and
exactly
then-
why we went with the 11, but I'd be,
One other question I wanted to ask Alex, if I may, is, do you have any exceptions? When we had our public hearing, we had, a developer in here who was doing workforce housing. And we actually delayed this, I don't know what the status of that is, because we want workforce housing in the city. So, and if we had passed this legislation back earlier in the year, it would have thwarted that project. I don't know whether if they're in the pipeline, they would not be covered by this.
No,
They were-
they're waiting upon another piece of legislation that's before you this evening in order for their project to move forward.
I hope it's not
It's
on
going-
1918, because I hate that piece of legislation.
Which project are we talking about, where there's workforce housing?
Town courts, off of West Street, actually accesses off of Capitol Drive, right across from the Monarch
But the-
Academy. It's a 42
Okay.
unit.
Is this 11 units tied in any way, or was that number chosen because of moderately
PDU.
priced dwelling units?
No, it's the
Cut it
thing
out.
that's the thing
PDUs.
up in
Yeah, I
Title
didn't get
22 that it's applied to everything, except it doesn't make any sense because as you go through, like traffic studies is based on trip generation, not number of units.
Mhm.
But everything under Title 22 with APF is tied to increases by 10,000 square feet or more than 10 units or 11 units.
So that's where the
That's-
11.
It's just I don't know, it's when you did whenever you adopted adequate public facilities. That's why it's 11 units.
So the generic question is, are there exceptions for specific type of housing that are deemed socially desirable for the county, in our case, for the city?
In the county code, no, the only exception is there are a couple, so the Mills Pearl Town Plaza is exempt, the Odenton Growth Management District is exempt,
Yeah, I don't agree.
and then there's a BWI, TDOZ, Transportation Development Overlay Zone. So there's 3 specific areas that are exempted by map, but there's not a specific exemption for workforce or moderately priced dwelling unit exemptions.
Yeah,
or-
see, I'm
Is that-
uncomfortable with that personally because, I mean, the whole point of this is that we don't overload the schools. I don't know whether you have notions in the next comp plan of having opportunity areas again that might be exempt from this. We need to have an examination of the 4 growth opportunity areas and see if anything is really happening there instead it's all happening in Eastport.
I thought
Well,
you don't wanna
the
make
issue
that a
is
growth
These
opportunity.
areas allow growth to occur, even though they could be impacting the school district. These
Yeah, no, I know.
exemptions. So
And I'm
they
not-
allow for multifamily exemptions in the Parole Town Center. So
Mhm.
Marist, even though the school may have been closed
Right.
over 100%, it got developed, 300 units went online in the county.
But that hasn't changed.
No, those
That-
exempt zones have, obviously, Mills Pearl was first,
Mhm.
and then Odenton was second, and then the most recent addition is the one around the airport.
Mhm.
But how does that make sense for the school board? Because that means they can pile in more kids and not trigger the APFO, which means you're gonna have a bigger population.
Right,
For
so,
you, it must be a nightmare.
they largely, the county did TIFs for those, which
Right.
is tax preferential financing, and it's my understanding that, that there's a lot of peculiarities and legalities of how to do a TIF and how to be eligible for that type of, financing.
Don't worry
And-
about it, it's Alderman Payon.
It's Fred's.
So I think part of it is tied to being able to finance those targeted growth zones.
Okay,
But there's nothing to preclude you from putting an exemption for, certain type of workforce housing, or if it's federally funded under some subsection of the housing code. I mean, you can create
Right.
your own exemptions, but,
Mhm.
I mean, that's a policy decision for this body.
Yeah, but it would bring back pressure on you. We say, oh, we're gonna limit development so we don't overcrowd the schools, except we're gonna allow all of these things.
Well, I guess I'd be interested in knowing, how much, for example, the town center. You know, clearly that was not designed for people with children.
Right. So last year, we had one student. So there's two high-rises there.
Yeah.
One's condo and one's apartment.
Mm-hmm.
We picked up one youngster from both, from that entire two
Mhm.
high-rise structure. We
Right.
picked up one child on a bus.
Right.
So I think the plan, they recognized that the type of development that was
Yeah.
going in was not gonna be the type that was
Right.
gonna have a lot of kids.
But workforce housing, I think, might be much more likely to have children.
Well, yeah, the project that's going in, off of West Street, behind, I guess it's behind the Double T Diner.
The
Has-
Maris building?
Mm-hmm.
I thought that was for older people.
Is that for seniors?
No, that's not age restricted.
Yeah,
That's market
but-
rate.
Oh, okay.
I just wonder, cause that's part of that, the
Town
Parole Town Center, configuration also, and
Right,
how
yeah.
much that has
I mean,
impacted.
most of those units are really, don't kind of want to show my age here too much, but I mean, they're really geared towards sort of younger, higher income, younger, very mobile population that typically the amenities, the environment of those buildings isn't really pitched towards families with children. There's no restrictions on that. I mean, so there aren't. So there is a risk, but our casual observation is that those units are not attracting that many youngsters with families.
So, all right, so do we want, to, and Gary, can you help us, Mr. Olson? If we removed, C1 and 2, that takes out the specific numbers, the percentage, the 95%, and, would we remove,
We're gonna have to really work on the wording, because you got that colon, and then there's the section for elementary and middle, and the section for high school, and I
Right.
think, you know, units shall not be approved where, we don't need the semicolon, we'll just say where, capacity exceeds the county standards for elementary, middle, and high school.
well, would it be necessary for us to give those percentages? I think we were saying the same thing. We wouldn't need those paragraphs at all, and simply say that we will, use the, standards
Yeah,
as
that's what I'm
defined
saying.
by the county.
Yeah,
So we wouldn't need one or two?
Yeah.
Just get rid of the semicolon after where, and
Okay.
say, if, school capacity exceeds the county standards, which right now are 95, 100, and may revert back to 100, 100. But that's.
I wouldn't want to be accused of practicing law without a license, because clearly I've only got 3 credits under my belt here. But a lot of times, the way I see, and Mr. Ellison, I'm not sure if you see this frequently, is that you adopt, I mean, you say as enumerated in code, you know, in title code section, and you put the exact
Right.
section of the county
Of the
code
county code, yeah.
Yeah.
right there, and then you have a legal reference that's
So
fine.
do you have the reference handy right now, by any chance?
But
Are you comfortable
is
with
everything
this?
else the same in the county? For example, I mean, because we talk about, I'm trying to find where it projects out for 3 years.
3 years, projections out for 3 years, and then we also take into consideration plans in the pipeline
Right,
for doing the projections.
well, we could leave that.
Yes,
the
Yeah,
same.
we
we
have
say
to leave
within,
that.
Does the county do that?
So they are not officially counted into projections until they've been granted either sketch plan approval or final plan approval.
That's right.
So that's when they vest, essentially. So when they're a conceptual project, it's still a concept, and you don't know whether project's ever really gonna come to fruition, so we don't count them. But once they receive their, subdivision or sketch or final subdivision approvals, We then we work with the developer to get from them what's called a build-out schedule. Because just because there's gonna be 133 units, you're not gonna bring all 133 units online. So, my staff and planning and zoning office works with that developer to say, okay, you're approved for 130 homes. When are you gonna break ground? How many do you think you're gonna bring online per year? And so all 130 homes don't immediately show up. We sprinkle those homes across the projections.
In addition to your grade succession ratios.
Yes.
So,
Yeah.
but do you?
Mr. Ellison, I don't have that with me, but I'd be happy to work with you tomorrow even.
Sure, you
or
probably have my email.
offline.
Yeah, I mean, I know we've been in touch on many cases in the past, so, you probably have my email address. If you wanna just send me an email, let me know what the
Okay.
section of the county code is
And
that we're talking about.
and if you need to speak to the subject matter expert in the county office of law, is Greg Swain.
Greg Swain?
Greg Swain, he's a supervising attorney that staffs planning and zoning and inspections and permits. He's really the go-to
Yeah,
person, not just with this, but with history, because he's been involved in it as long as I have. So he's got a lot of perspective on this as well.
okay.
So I still have a question though. Like, does the county look at the 3-year projection when determining if the projection's at the cap or below? Do they look at 3 years or just the next?
Well, so our projections actually are 10 years. The ordinance says you look at the projection 3 years out.
Okay.
And again, that's the recognition, that's kind of the conversation we started to have, that even if a project was approved today, they're not gonna break ground tomorrow. So by the time they get through the rest of their regulatory approval process, by the time they get their financing in place, by the time they're, mobilizing, it is reasonable to assume that they're not gonna bring the first unit out of the ground for as much as 3 years out.
Mm-hmm.
So that's why when the county adopted its current version of APFO, and that was back in 2005, it was agreed upon, again, in consultation with the building community, that the fairest thing to do would say, let's not look at today, let's look at 3 years out. That's one answer from the developer's perspective. From our perspective, it takes us about 3 years to bring a capital project online as well. Because it takes about 1 year of planning. By the time you plan it, design it, get your permits, that's about a year. And then it takes us a little bit less, but about 24 months to bring a school online. So starting with a piece of dirt, I can deliver a school in a little bit under 24 months, easy. So again, that made sense because the developers aren't starting for about 3 years, and if you gave me money today and said go, I can get a school online in 3 years as well. So that just seemed like the natural spot that everybody could agree with.
Mm-hmm.
What about the MGT study, though? Would the school have to be placed in the MGT study to get placed in the?
No, so the MGT study is the consultants produce that as information to the policymakers, the decision makers. So the MGT study has no force of law. It's just a study that we took as input, and then the board and the county and the state, we only operate off of what is the approved CIP. But naturally, the way that the CIP is structured is greatly influenced by the MGT plan, and our history now over 2 cycles is we've not moved projects, up or back outside of that MGT recommended order.
I guess what comes to mind is Tower Heights.
Mm-hmm.
Because at one point, and I don't know how many years back it has been, when it was very high, like number 2 on the list,
Mm-hmm.
and then it fell, and then
Right.
it came back. But that was from the force of Board of Ed's choices or the county's choices
Board
or
of Ed's.
political.
No, Board of Ed's choices,
Mm-hmm.
clearly. So when we do the MGT study, essentially any school that's already, and I'm calling it MGT only because they've done it twice, but that's not its legal name. But any school that's received planning approval, received construction approval, is in design or whatever, they're held harmless essentially. But schools that are further down the line basically all get reanalyzed. So yes, they could get reprioritized because of that.
Are any of our Annapolis schools, high on the list?
Oh yeah, and I'm gonna be asking for feasibility study money tomorrow. Don't tell my board, they don't notice till tomorrow. But for Hillsmere.
For Hillsmere?
Hillsmere's my very next one. Obviously, Tyler Heights, we're going through the contract award process. So the board is gonna be awarding contracts tomorrow. We've already started out at the site. You've probably seen a little bit of activity this summer, but the bulk of the contract's gonna be approved tomorrow. But when the board takes up my CIP, I'm gonna be asking for money to do the feasibility study for Hillsmere in FY 2020. I would like to design it in FY 21, and then I would like to construct it in FY 22 and 23. So by September of 2022, if I had my way, if the funding authorities help assist me, we would have a brand new.
Is it brand new or renovation?
Well, whatever,
or-
renovated or reconstructed, it's whatever the feasibility study ultimately determines.
So what else is left in the city? I mean, most of our schools seem to be newly renovated, or I can't think of a school that hasn't had some renovations within the last
No, I mean,
5
and
years.
the other big project that I'm asking for from my board and from the state, again, don't tell them, is I'm asking for to replace the entire heating and cooling system at Annapolis Middle School, because it still has window air conditioners. It's still one of the
Yes,
few
it
that does. So I'm asking for a significant cash infusion to be able to comprehensively put in an entire new heating and cooling system, get rid of the window air conditioners, et cetera.
I was just there last Wednesday morning greeting the kids, and I noticed, and I was surprised that all the windows have air conditioning in it.
And if I was to guess, the next building after Hillsmere, Indianapolis area, with all due candor, would probably be Bates. If you were to ask me what the next one probably would be after Hillsmere.
So the
Just
middle,
thinking about, because you're right, so many of the other schools have already had significant work done in them. And Bates has had a lot of systemic and maintenance and component work, but it's not really been comprehensively redone for, a long time.
okay. Rob, Alderman?
Yeah, thank you, Madam Chair. Just two other questions. Do these numbers take into consideration the Monarch School, the capacity numbers? Actually, you may not have seen this, but I'm looking at the chart that was provided by our planning and zoning.
So these, the current APFO ordinance is predicated on our 2017 Education Facility Master Plan. We now have a 2018 Education Facility Master Plan. So the county in November is going to be adopting a new APFO open close chart. It is going to be based on the most recent set of data.
If I could interject, yes, we got this from your staff, and these include the changes for Monarch Academy, so they,
It should,
Scott
if
Schuler-
this
Scott-
is
I think
out of the
Scott-
2018 master plan, which I think it is, the numbers look the same, and I was just starting to look at a couple of them. It does include Monarch Annapolis.
So are the Monarch School kids still labeled in their own old schools? Because it's not listed as a school here.
It is and it will be. It should be, honestly.
this was adjusted based on what we got to the elementary schools based on the reduction. That's why I think there was, Mills Parole opened up
Right.
from last year.
Oh, it was close. I was gonna
Yeah,
say,
it
I
was
was surprised
closed.
that's so high
I
after
think-
the new construction there.
And the Monarch School is going to be adding about another 130 students, or they're not going to be. They just did add about another 130 students this past year, some of which obviously came out of our schools, some of which could have come out of private schools or homeschool type environments as well.
And I heard that was opened up to students outside the Annapolis cluster?
Just we gave them a one-time exemption because they were still a couple seats short. Basically, their business model is, I mean, we're paying them tuition and they gotta cover all of their overhead and everything, and there's a provision in their contract that says if they can demonstrate to the board that they've exhausted all of their ability to get all the students that they need out of their catchment area, and their catchment area is absolutely only the Annapolis feeder system, they can appeal to the board and say, we still have a couple open seats, we've done everything possible, we've had as many outreach events as possible, but we still have some open seats. In order to help our economic viability, will you allow us to bring in youngsters from outside of the district? So the board granted them a one-time unique exemption to do that. But that exemption isn't automatic, so it doesn't automatically renew our goal, and the Children's Guild organization that runs, we are both 100% committed to having every youngster there be from the Annapolis feeder zone, period.
Good.
Period.
So what's their enrollment now?
I think they're going to be a little bit over 600. Let me see if I have that. I think I have that here. I think they're going to be about 630.
Their capacity is what, 800?
Yeah, so the contract that we signed with them had a 3-year phase-in plan, so they opened up in the mid-500s, and we allowed them about another 130 students in the second year, and then they're gonna get one more slug of new students next year, and then they're gonna be at full capacity.
I had a question for Director Gutwald. Could you explain a little bit about your table here? What I'd like to know is when in the process do projects have to go through this evaluation? Like when do they receive their APF certificate?
They get their certificate of adequacy at the time they receive site plan approval. So it would either be in conjunction with the plan development, or it's when we issue a site plan development or site design.
Okay.
So,
Well, do they come to us or go through the county?
no, they come through our process. We have our own APF ordinance, and then we have testing periods. We have 2 different testing periods, which is another question I have, but based on, you know, what's done with the master facilities, and then what, of course, changes September 30th, you know, with the new enrollments that have occurred. So we do a testing in January, and we do a testing in July 1st to account for redistricting or capital improvements that are programmed. But we determine at that point in time whether the school is reaching the capacity or not. We add in, so you understand, there are projects that Anne Arundel County Public Schools have incorporated into their grade succession ratios, and we work with them as to which were those projects, or how accurate you are with Parkside Preserve. I'm just kidding. Since that's been on the books for over 10 years.
Yeah.
And then, of course, we do the analysis and use their pupil ratios, student ratios per type unit, and add that into the 3rd year. As you see in our chart, we add all the students in the 3rd year. Don't look at a program, say 3rd year, assume all students, all units are built, and added that number of units into the 3rd year and say, okay, are you over or under the 100%? So we don't phase it in, and that would be my question. At what point in time does the county add capacity? You talked about a school coming online, it's 1 year for planning and engineering, 2 years for construction, and that 3rd year, that school should open. At what point in time does the county add that capacity into the utilization charts?
Sure. So the capacity, the way that it operates is the capacity signed when the very first construction contract is signed. So we have appropriation authority. It's been planned and designed. It still doesn't add it into the numbers. But as soon as the very first construction contract is signed, then that is sufficient grounds, basically, to know we have the appropriation authority, we have contracts in place, that it's going to come online, so that's
So
the trigger.
but you added into the capacity and say that the school's under under the standard, and therefore projects can move forward and they
Yes.
can approve them? If it's a brand
Well, we
new-
don't, so we know, because we're not the planning and zoning officer for the county,
Right,
we notify, when capacity is created or comes online, we notify Mr. Hager, that's the planning and zoning director for the
Uh-huh.
county. He's got the authority then to modify his standards, his review criteria.
and so how would he know if it's a new school, what schools would be relieved and which ones wouldn't? Would you direct that?
We notify them in writing. Obviously, we communicate with them all the time.
Sure.
But officially, I write a letter to Mr. Hager that says, you know, 6 classroom addition at such and such school, we just entered into contract with, the capacity of the school is raised from, state rate capacity for the building is raised from 588 to 679 now, and he will then begin using
That number.
the higher state rated capacity.
Complexity would be with redistricting, or if it's a new school.
Right. So again, I think, you know, we typically keep in pretty good communications and share a lot of information back and forth.
Yeah, we do too, with Scott.
Yeah, exactly. That's the way it works.
Just wondering how that worked, because that's sort of the quagmire, is when, if there's a redistricting and when the addition comes on, not knowing, like Monarch, not knowing which schools would be relieved based on
Right.
it, we had to wait till they had redone the projections and got the numbers in order to determine that the school was under or over, so.
Right.
I wasn't gonna sit there and say, yeah, there's 300 units capacity, Mills Parole's open, I couldn't do that. I needed to actually see the numbers, so.
And unlike a conventional, you know, for the alderman, unlike a conventional redistricting, the Board of Education controls basically the geographic attendance zone for each school. They can, you know, vote on it. But attendance at the Monarch School is by lottery. And so for charter schools or contract schools, the attendance is done by lottery. And obviously, on a lottery-based system, you don't know exactly, you know, who's ultimately, A, going to be through the lottery offered a seat, so that's part one. And then B, just because they're offered a seat, you don't know if they'll accept it, because some families apply to 2 or 3 programs. They could apply to be a student here and apply to a magnet school and apply possibly to a private school. And so it's not really until the youngster shows up
Sure, but that's the
that
same thing.
you actually know that you have them. So, but that's a one-time anomaly, basically. Now that, you know, the Monarch School is getting to a steady state condition, we really shouldn't have, you know, we redistricted Annapolis comprehensively. That probably won't happen again for a good number of years.
It
And
was brutal when it was happening, so.
it's very
I'll just
painful.
say.
It took 2 tries, as you
Yes.
recall, Alderman. And then the Monarch School, I think, is going to reach a steady state and help all of our predictability and analysis.
Did I answer your question, Alderman Savage?
Thank you.
Okay, good.
And the question I asked about whether it was the county, I was talking about school construction, you were talking about residential construction.
Oh.
So anyway, I'm
Sorry.
good. No, but you guys. So, are we comfortable, Gary, with, you going back, and Alex, if you'll share with him, or, the.
What I intend to do is I'll send him the entire, I mean, the code sections are there, but I think it will be beneficial if Mr. Ellison has the ability to review the entire code section that applies to adequate public facilities, and then he can determine how best to cross-reference that.
So are you gentlemen comfortable with, Mr. Elson working up the language for the amendment without needing to see and read the whole?
I mean, I would certainly, you know, after I draft something, send it to the 3 of you, you know, for review.
So that is, first of all, looking at the time, I don't know how
I
long
know.
we want to keep Alex here on our
I
dime.
thought we were
I'm
gonna be
okay.
finished in just
No,
a
I'm
few
okay.
minutes, so,
Don't-
yeah.
Right.
I'll stay as long as you need me.
So the process would be Gary would send us by email, and then we would comment back, but assuming we don't have other changes, we would report out to the council with this one amendment,
Well, I think we should vote on the amendment
Yeah,
at
I
some
think
point,
the
so.
amendment would be
Can,
to eliminate paragraphs 1 and 2 of paragraph C, and then just incorporate language that would reflect that the city would follow or adhere to Anne Arundel County school capacity, would it be standards, Alex? Standards? Yeah, standards, as set forth in whatever code section it is.
So moved.
Well, I'd rather we get it, and then we can do it by consensus. Alex, sorry, Mr. Second.
I'm just trying to be helpful, I hope. And so, if you do that, just understand that your 11 dwelling units becomes 5 then.
Well, that's my question. If it's just, are we adopting just the standard, the percent utilization, or all the processes and procedures? Because we do, our calculations of pupil yield generation to students is done differently from their way. So that's why I said standards would be the issue, not necessarily taking in the processes and how you, because do they still have open, close period, and it's decided at one point in time and that's it? And then it's closed until the following year? Because we
Well,
have,
it's closed until the adoption of the next chart.
until the next
So
chart, but
the county law says they have to introduce a chart at least once a year,
right.
but it can be as frequently as they wish beyond that, so.
And the city council is the one that the county council is the one that makes that decision and when to adopt it?
Yes.
Right.
The
So there's
administration-
different
Is this the chart
processes
you're
and
referring to?
procedures. No, they got a different chart. That's why I'm saying our chart is a little different because we add all the pipeline development in the city and add it to the third year. It doesn't necessarily take into consideration, projects that are going outside the city, that kind of stuff. Plus, we add it all in the third year. So there's other nuances, is my point, as to what we do and how they do it versus the way we do and how we do it, other than the standard. I thought you were just adopting the 100% versus the 95%.
I have a
Wait minute,
suggestion.
Rob, Alderman Arnett was.
Yeah, so that, first of all, my overall goal would be to be as consistent with the county as feasible, but my specific sense of this was we were just going to be adopting their thresholds, not
Because we
dealing
could
with
just
anything else.
adopt their chart, whenever they adopt
Well,
it.
that's true.
Well,
can I
For
make
the
a
open
suggestion?
closed, right? They have an open closed, they adopt it at least one time a year, we could just reference their chart.
So when they
If you look
adopt,
at the code, the ordinance, the only thing we're striking are the percentages. So if you look at paragraph 1, we could just say, it says, let's see, educational facilities master plan is currently or projected to be equal to or greater than, can we just reference the county?
We could do it that way,
The
too.
county's percentage.
I don't have a code, but
or-
that's what I thought you were doing, yeah.
yeah, we could do it that way.
And then you just have to edit the last sentence of both those paragraphs, 1 and 2.
Or do we
That's
need,
probably-
can we combine,
Well, so where do we add, cause this is grandfathered. So that's why I thought if we were using the counties, we would use their exact language for that, as opposed to putting in the numbers. Because the numbers can change
Yeah, we're
this
not,
time
we're not
next
talking about
year.
putting in the numbers.
yeah, we're not,
Done.
yeah.
Oh, I thought that's what he was saying.
No, I was
No,
suggesting
just saying-
referencing that we would use the percentages
Right.
that are used,
I mean,
currently
you-
utilized by the
Okay.
county.
You can combine paragraphs 1 or subparagraphs 1 and 2 to just include all schools, because all schools will be corresponding. There's gonna be no distinction unless the county makes a distinction, which right now you do,
Yeah, they do.
yeah. So,
And high school, I think, is a different animal. We've heard arguments about how, there's AP and BEA or
IB.
IB and all of those things. And also, it is the one that is projected to be over 100% with this table, the high school. If the high school's overcapacity, everything is done. Doesn't make any difference what is happening with the other schools.
Well, but the school system, I'm assuming, would make programmatic changes. Annapolis High School has IB it has
PVA.
PVA, it has ESOL. So wouldn't the board consider making some shifts in those programs so that we're not at capacity in 20, whatever year that is?
The board really has three options. They can do programmatic shifts, they can do redistricting, or they could put another capacity addition onto Annapolis High School.
Okay, so it doesn't necessarily mean that it's
No.
just over capacity and
Right.
we ignore it. There are some remedies.
Well, the county makes a distinction for the three different categories, elementary, middle, and high school. And again, in my goal of consistency with the county, I don't see why we shouldn't make those same distinctions.
But-
So I think this changing the language to take out the specific percentages and put in the reference to the county thresholds.
But since we're gonna be following the county with respect to all three levels of school, do we need both paragraphs or subparagraphs 1 and 2, or can we just, there's gonna be.
Yeah, because then you have a 1 and a 2 instead of just a 1.
That's a real good reason. I mean, either way,
Good
it's.
thing I have a meeting tonight.
Oh, yeah, there is another meeting
Pete,
coming
what
in
do
here
you-
at 7 o'clock.
I hope we're gonna be done before.
Oh, yeah. Well,
Okay.
I
Just
don't,
kidding.
and I understand what you're saying, you need a 1, a 2.
I want to.
So how about we let, Gary, not Gary, Pete, are you good with just changing this portion of it without
Yeah,
changing the
I-
processes?
I would, yes, because because they rely on the county council, and this is done, it's done. Whatever
Yeah.
the school board gives me,
Yep.
it's what it is. I don't
Yeah.
worry about what's going on, because they've changed things before, haven't they?
Right, so that's why I asked the question. I think it's better for you to just adopt their open-close standard, but not adopt their whole process, because your
Yeah.
process is different.
Yeah.
You should have the latitude to use your process unique to the city and not,
Correct.
I think it's a better way to just adopt their standard. And again, I can work with Mr. Ellison
Okay.
to get the correct percentage figure in, but not prevent your department from operating the way that you historically have operated.
Okay.
I would agree, yeah. I mean, that's, even his staff has told me to do that.
We could,
So
So-
Pete, are you good with the 11 units remaining?
That's a policy
consistency.
decision.
Well,
That's the way we do all on Title 20. That's just how it
Okay.
starts off in all of Title 22. for
Right.
Is that the way it
Okay.
was done prior to
schools.
the last change?
I'm sorry?
Was that,
No,
is that,
that was
how long has it
there.
been done? How long was that 11 unit?
Long time.
What do you
I
mean
thought it
done?
was something,
Schools have just been recently added. Schools was never part of Title 22. That was what's been added.
okay.
And that 11 and 10,000 square feet has it was the opening paragraph to Title 22 for all the different things.
But I was under the assumption that that was done simply because a particular
I don't know.
alderman wanted to capture a certain project. I don't know.
I thought it was done.
That number 11 has been there as long as I've known.
Yeah,
it was- Okay.
It's some
It was to be
historical
consistent.
legacy number.
Okay, then
It
it
was
must have been bad
consistent
information.
with
I
other
heard.
parts
Okay.
of the code.
Yeah.
Okay.
I don't know.
So if you're good with,
I'm fine with that. I
okay,
mean,
so we'll let, you guys get together and send us, whatever change
Right.
that we could,
it could be
but it
related to
will, it will be,
MPDUs.
it will not change
Okay.
anything except
That's a
that
good
for,
connection.
elementary and middle schools and high schools, we will, at the end of each paragraph there, 1 and 2, we will just take out the percentages and indicate that, it would be equal to or greater than whatever the county is going with at the time. So, that's not the language that'll go in here, but
Yeah,
that's the
yeah.
concept. Is that okay?
yeah.
Yeah.
So you
moved.
don't need to speak to grandfathering or
Well, in what respect? I mean, what do you?
it'll just say we'll do whatever the county does, period.
Yeah, it'll take effect from the date that the law is adopted by the
Yeah.
council, and so,
And at the rate we're going, they'll change it again before we get this done.
Yeah.
I'm
I
just
mean,
kidding, I hope.
are you gonna be able to work with what, with whatever the county?
Just keep in mind, if you don't have a
standard-
certificate of adequacy, we don't issue that till we give a site design approval. So anything that's going through the pipeline that does not have a certificate of adequacy, they're subject to these standards. We would
Right.
test them at these standards.
Right.
Mhm.
So, are there applications in right now that are,
Mhm.
how many approximately, do you know?
Off the top of my head, that are more than 11 units, 5 or 6 that I talked about for forest conservation.
You have
Yeah,
some-
those are probably it right there, right.
You
So
have
th-
2 different columns, though, I don't know which,
So the ones on the left are approved, and the ones on the right are the ones that are outstanding, so, yeah, at 280, well, 285 is recently, Sailor's Quay, well, that wouldn't be affected, neither would Terrapin's Run, but they're still added into the, so those are probably it. So there's a handful.
So, the question comes to mind then, right after letter C, which residential developments are we talking about, other than exceeding 11 dwelling units? Residential developments that are the subject of an application, from this point forward, whatever the date of adoption is? Sheila, were you talking
No,
about?
this is just, I think the way it's written is that if you don't have a certificate of adequacy, currently, what it was originally, if you didn't have a certificate of adequacy, you're subject to the standard.
Right.
Because Title 22 is a little different. A certificate of adequacy is actually good for 5 years. Plan development is only good for 3. You don't get under construction and have a phasing plan. You're only good, and a site plan is only good for a year until you have to ask for extension, which is weird. So you can actually ask for a certificate of adequacy without even having site plan approval. There's nothing prohibiting anybody from doing that, but I don't allow it. So, and then it's good for 5 years. So.
as
So-
much as I'd wanna go after Parkside Preserve, just kidding. I'm fine with, if they already have their certificate, then
Yeah,
let them go
Right.
with it,
okay.
what they've received, I mean, just personally.
So,
Right,
Madam
so-
Chair, I would, given the amount of, we still have to sort through 1418, and I do have some significant issues to discuss on 1918.
Well, let's finish
Well,
this.
wait, I was just gonna
Okay.
say, though, I think we're gonna have to schedule another meeting of the Rules Committee, in the next week or so we can get these changes back to us.
Okay,
and
let's
so
talk
we don't
about
have to
that.
vote now.
Yes,
can
we're
I-
not gonna vote on it now,
Right.
Can I make,
because we need to see the language, and we are gonna, I was
Oh.
gonna bring it up later, because I think we are gonna need another meeting, so let's plan. If you guys can get this together within the next week,
Yep.
that would be very helpful.
Okay.
There, in regards to what the original, meeting was gonna be about, the APs, which I still haven't gotten yet, by the way. But, if we wanna get them on for the 24th, the draft agenda goes out this Friday, but Jacqueline said that we would have until the 18th,
So we'd have to set the next meeting prior to the 18th.
prior to the 18th, I'm sorry.
Yeah, so we'll look at our
Yeah.
calendars
Right.
before.
so you don't wanna vote on, I'm comfortable making a motion using what Gary has laid out, and then getting our recommendation in the
If we're
pipeline.
gonna have another meeting, I
Yeah.
don't see why we don't just wait to
Yeah,
get the
I
language.
would
Yeah,
rather we wait and see
it-
it before.
Either way would be okay, but because you're gonna have another meeting, you might as well wait,
Yeah,
yeah.
So you're
So-
thinking next week, you said?
well,
you were?
sometime before the 18th.
By the 7th.
But let's go to the next piece of
Right, well,
legislation, then we'll
let's thank
come back
Alex-
to.
Alex for
I-
his help.
Would you give me a chance? So we're gonna table.
I'm leaving when he leaves, by the way.
No, you are not. We're gonna table this because Gary and Alex and Pete are gonna get together and come up with
Okay.
whatever language we need to amend this, so that it's workable, and we'll bring it back before the committee at our next meeting, to be determined at the end of this meeting.
Okay.
Okay. So thank you, in such short notice, Alex, I
It's
really
okay.
appreciate it.
I don't mind.
Really
I
appreciate
think
it.
it's for a good cause, so thank you very much for collaboratively working with us as you always have.
We're in this
Thank you.
together.
Thank you.
Thank you.
And you guys were here last night, so yeah, I mean, you live here.
Yeah,
I'll be here tonight.
yeah, me too.
All right, so let's move on to the next item, which is 01418. For the purpose of clarifying the notice requirements for community meetings, clarifying the project applicability requirements for required community meetings, designating the office of the mayor as the point of contact for obtaining a list of associations whose membership could be affected by a proposed development, making minor editorial corrections and matters generally relating to the review process for all significant and substantial projects. And Alderman, now my thing isn't open. We have the draft that was provided that incorporates all the changes, but you
Right.
can't see what's new and different
You
in this
cannot.
draft.
But
So-
I can, because I
Cause you're
went through the two.
Superman, so you.
No, because I sat down to do it. So I guess if you have a copy of the legislation as submitted, the first thing I noticed is on page 2, it looks like number C, which is consistent with this, goes away entirely. Is that correct? So that's the first, that's part of Amendment 1.
Okay, let's slow up, because C on my new draft is the same as C on, no, it's not the same. Doesn't go away, but it's changed. When a
So
subdivision,
the first, remember, we've got these million sets of multi-page amendments before we got,
Can
so
I-
we have 5 amendments. Before we got to Pete's magnum opus to sort out the issue that Rob correctly brought up.
But I thought you guys already voted on on 5 of the amendments, and it was just down to amendment number 2? Because
Yeah.
most of the amendments were
Exactly.
cleaning it up, they were redundant.
Yeah.
But I
but we
suggested-
don't have those amendments in front of us.
They're-
Kia, do we have them?
They're on they were added to the one that's on the agenda. So if you bring up
Yeah, it's
if you bring
the
up the
proposed
staff report,
rules.
I think? No.
I don't see any amendments.
If you bring
Oh,
up
yes,
staff
it is.
reports-
It's at the very bottom.
Right.
Oh, there it is.
So
yeah.
Amendment 2, what were we doing with Amendment 2?
So,
Yeah.
you want, so.
Amendment 2 or Amendment 1?
My
I see 'em.
my concern, the 2.
Two.
Number 2.
We'd approved.
Okay,
My,
but, let me ask.
You approved 1, 3, 4, and 5, I believe.
Yes.
Yes.
Okay, so we've approved Amendment 1. Okay, Amendment 2 is the one that we sent back to the team.
Team?
Hmm.
Yes, the planning department, the law department, and Mr. Hyatt, right? And 3 is the one, we already approved 3, correct?
Correct.
Correct.
And we already agreed to 4, correct?
Correct.
And we agreed to 5, correct? Okay, so we're not revisiting those again. So let's go back now to Amendment 2, which is on page 3 of the amendment packet that's in our,
I have the last one.
that's attached.
Hmm.
Do you
And
have-
that starts with page 3, lines 31 through 40.
Right.
Is that where we are?
Is it? Yes, 31.
Just didn't print it out.
Community meeting.
I think we were mainly focused on the notice requirements.
Do we have a document that shows the, what you did? Is that a separate,
We have that, it was passed around by email, I think this is
Right.
it right here,
Well, you can see on page
It
4
is,
and 5.
it is.
yeah.
So,
is this the new language? Is
I'm sorry,
the
3
as
and 4.
amended part on the bottom of page 3?
do you want to see it?
Yeah, see, I thought it was the community meeting where we had run into trouble.
Well, that's what we're talking about, that's,
Right.
this
Yeah.
is, but
Well,
I'm not
this
seeing
was-
B as
This was
amended.
done, my concern was that it took out some steps in the process for the standard general public notification process code section. And so the changes they made is, essentially, it looks like you kept that in there. You kind of just restructured things to make sure that was still kept in that standard for
Yes.
public notification requirements. So, you know, my concern's been addressed, so thank you. And you also worked in the newspaper notification, which I
We did,
requested last time.
yeah.
So I'm good with what was created.
So what's,
So let me just get a little background and then where we went, and and then Alan and Gary and I went back and forth and all around the mulberry bush. So, what it was we were trying to do was separate the notification requirements for just the community meetings versus all the other notification
Right.
requirements.
mhm.
Right.
I think Alderman Savage felt, wait a minute, that's reducing the transparency, if you will, or lack of a better word, that we should, the same notification requirements should be applicable to everything. So we went back to that, and so, just so you know, the business associations, the civic associations will get notifications of variances for for a 5-foot side, side yard setbacks now. That's where we went. We were trying, staff was saying, well, we don't wanna do that, this was just to do the community input meetings, notifications to the associations for community, when you have a project that meets the requirements for community input. That's not what Mr. Savage wanted, so we went back to that, and then we clarified, to get around, the geographic area, the catchment area, we just said 200 feet. Put a very definitive number. If that business association or resident association is within that 200 feet,
Well, the mailing address.
the mailing
Yeah,
address,
but that's wrong. That's a problem.
we would, is the mailing address? But,
No, the mailing address for the civic association is a post office box, and this project could be down at the point. So you can't, I don't think you can use the mailing address as a reference.
I don't think it said mailing address.
Yeah, it does.
Okay.
We had, that was
the-
about the 5th iteration of this. We
Right,
had tried to
So we
figure out
just-
other ways to do
You
it.
just were trying to get rid of catchment area, I
Well,
know, but,
Did you hear
Make
that,
it very
Alex used the word
succinct.
catchment today? Did you
yes,
catch
I
that?
know. Yeah, it's a,
And I was
Used by
hoping he
other
would not,
jurisdictions.
it was a beautiful word.
Yeah,
It is a
right.
beautiful word.
Right.
Anyway, so that's the genesis of Amendment 2. We included the standards for all of them, for every type, for anybody that has a notification requirement, these are the standards that they will have to apply, even whether it's community input or not, whether they meet the standard for that or not, and then defining the area, geographic area for the community associations and business associations, so.
One of the iterations we had was that, with respect to the associations, that the mailing address, let me see if I can get this straight now, was not in there, and we used boundaries of the, development that the community, that the association is associated with. So if we have, like a, I mean, you're not gonna get a square, obviously, but if it goes around in any direction at all, that we would have the associations mail out within 200 feet of each. I mean, you take the line around the development, and it's 200 feet out in all directions. I don't know how difficult that would be, because usually, or many times, they ask Sean Wampler to, I think, doesn't Sean
Yeah,
give them
GIS, yeah.
to do it, the GIS, to give them a list of the property addresses that are within 200 feet. But I think that's, so if you have like one lot, one rectangular lot, it's easy to do. I don't know if it would be, without asking Sean, how easy it would be to do if you have, boundaries of, of a development that are, not as routine as a rectangle or a square or something like that.
Might be easier just to bring out the old hard copy map and scale it off.
I'm not, yeah, it could be easy to do. We didn't check with Sean, but that was one of the things that I think I had mentioned to Alan and Pete, why don't we just do the boundaries that are associated with the community association, the business
And
association.
that's what I struck out. I mean, I don't know what the problem is with catchment, but you can have the membership boundaries encompass the proposed development. So ECA, and it may not be the case, like EBA, I think also has an area that they draw members, and it's people who do business in Eastport, which is an undefined term, but you could say do business within Ward 8. Sean can certainly look at Ward 8, and she can identify the business zones, B1s, B2s, and say, okay, those people. So it's really 4th Street, 6th Street, you've got the shopping center, and you've got Bay Ridge. There's not, I mean, it wouldn't be that hard to define EBA. Now, I don't know about other wards. So like you in.
We don't have the
I-
same types of agents or organizations.
Well, some do, like
Some
SOFO.
do, but-
SOFO does, right.
Well,
I-
SOFO doesn't represent, everybody on Forest Drive, for example.
No, but it is a business organization,
Yes.
and it does have a defined boundary, and if there was a project that was going in their boundaries, they would be notified under the system.
So that means that they would be notified of anything.
That's,
I think they should be.
right,
I mean, I am concerned about the post office box.
yeah,
Because, I
it
mean,
just can't work.
because there are a lot of them probably have PO boxes and not physical. I'd rather have it say if I'm trying to think how to best word it, but if the community that the community association represents falls within 200 feet, then they should be notified. It's not just about where the physical mailing address is of the community association. It's their.
Well, you're saying that you don't wanna use PO boxes.
No,
No, that's what
I'm
Ross is
saying,
saying.
I don't wanna use post office, there's two ways that people tend to do it. One is post office box, the other is the address of the president or the secretary, most likely the secretary.
Which changes.
That keeps changing, yeah, right.
Hard to
But the
track.
membership boundaries don't change. I mean, ECA did change their boundaries recently to include, the public housing in Ward 6. So they did dramatically
You
expand
mean
the boundaries.
Harbor House, Eastport there?
Yeah, and so that's why Shanika comes to the ECA meetings now, because we've included part of her ward. And she
Okay.
speaks and, gets up and speaks and gives reports and that sort of stuff.
I think that's something we could probably do with our GIS. Sean could
Oh,
probably
yeah.
do, is just draw a layer of, here's the Fairwinds community boundaries, which, the alderman could probably help her if she
Yeah.
needs help determining that,
We
but
will-
usually
once
it's.
we're getting going, yeah, we're gonna have to sit down, because, in Eastport, you've got the, Severn House Community Association, and the President's Point, and Sherwood, and blah, blah, blah,
Well,
it goes on.
what if we use Cashman Basin, but then in the definition, we define it as the area of scope for
I'm all for using
community
catchment
association?
I think one of the problems we had with catchment is we don't see it anywhere else in the code, and it's kind of a term that is, at least in my opinion, is not in great use. You know what I mean? I know Alex used it. It shocked me that he
Well,
used
so I
that.
changed it, I said membership
But he's
boundaries,
in the education
not
one, so
catchment.
you,
Okay,
you can say.
all right.
I said membership boundaries rather than catchment area. Membership boundaries, I think, is a pretty straightforward term.
Membership boundaries would mean, you could refer to specific lots of land.
I
When you
mean,
say
what I would
membership
do-
boundaries.
This is
So
Rob.
you're arguing
I
for
think it's better to link it to geography, which isn't gonna
Right,
change as much.
This is a job that Rob is, I think, gonna be doing, and I think he should sit down with each of the alderpersons and go over what are the organizations.
You?
Me?
Not, not Rob, Will, Ralph.
The time to do that, okay.
Well, Janice is the one who sent us,
Good
didn't
idea.
she already send us our list of,
Yeah, well,
Of-
whoever, it's the mayor's office, they have to do it, so,
Right.
and she did send out a request to us, and I did send her
Yeah.
something. So we would sit down
Did you get yours?
with Sean and
your list of
the mayor's
organizations
office.
in your
This is
ward?
something the
I
mayor's
gave it to her.
office needs for other purposes anyway. And
So-
we would go through a de novo exercise where we would say, here's all the ones we know about, and we would go to those organizations and say, where do you draw your members from? And we would define it once. Probably you're gonna have some housekeeping problems if somebody does like ECA did and expand or change their boundaries. I think in my tenure on ECA, we have changed boundaries 3 times, but this last one was the most dramatic change. It started out being pretty much what the R2NC boundaries were. Then they expanded a little bit more, but kept it in Ward 8, and then they expanded into Ward 6.
Okay, so am I hearing that we want to, instead of striking the phrase whose membership catchment area encompasses the proposed development,
Well,
we want to bring that back, take out the word catchment?
I
no,
think that's,
no.
no, I just think, that we have to look at this also in the context of the fact that we have litigation out there, and we have to work with Alan Hyatt according to the consent order that we have in that case right now. I know he did not like the word catchment. That doesn't mean we can't convince him, as long as it makes sense, but we have to collaborate with him by court order, okay?
Right.
But
Okay,
but we
so-
don't have to list.
But the final language is
we-
ours, the final
yeah.
language is ours,
Okay,
yeah.
Yeah.
so,
So
I mean,
what I
what are
was
we,
re- if
what
you
am I
look at-
hearing? Are we
If you look
changing
at
this or
this,
not?
the mock-up one, and you look on page 5, down at the bottom, under 1D, it says, business association whose mailing address is within 200 feet. I would say whose membership boundary is within 200, no, actually,
N- th-
I think
But I'm not
geographic
seeing that,
boundary.
is that under
I think
community?
geographic is
Meeting?
you
the
need to
right
look
word,
at the
I'm
amendments.
looking, this is the amendment.
This is, no,
Here's
no,
the
there,
amendment
yeah,
right
okay,
here.
fine, yes.
Alderman Arnett, and
Yes.
just, I do think the geographic boundary would be better because, for example, I know,
Just 1 second, this is vote. I think I'm in a meeting, can I call you back? Yeah, thanks. Gotta get
for
the vote out of the way.
example, I know a number of my neighbors, including former Alderman Pfeiffer, had membership, because he owned property in an adjacent community, so he had membership in both communities. So, I think the membership could be all over the city, so I think it's better to keep it.
Of the organization?
The membership could be, yeah,
Pfeiffer isn't an organization.
You're talking about the members in the organization,
yeah,
not the
because they could be
membership.
property
Well,
owners
yeah, it'd be
who
like-
are,
like
live somewhere
Sierra
else in
Club.
the city. and-
Okay,
Are we gonna notify the Sierra Club?
No, but stick to the geographic boundaries for the,
Right.
But,
each association.
but we
I think
are
the
talking,
Democratic National Committee should know about this.
we are talking about membership though, right? I think that
Yes, membership organization.
we're trying to figure out individuals and entities who get notice, so,
So it's membership organizations of the type that are specified. So it's including but not limiting homeowners, condominium, resident, business associations.
we're in
Who's-
different places,
Well, but-
on the original
you reading? from-
document, we're on page 3, the
Okay.
amendments, I have that. But
Try-
Ross is pointing to
Do you have
Page
it?
6.
something else. What is that?
That's what Jacqueline prepared for Alderman Arnett.
Yeah, no,
You got that?
they all have it. That's why I was,
Okay, so what,
I was looking at page 6 in that document, but
Oh,
if you're
page
looking,
5.
if you're looking at the original legislation that was submitted, it would be on page 6 of that. If you're looking at the amendments,
This says page 3,
Bingo.
lines 31 through 40.
Can I,
see, that's
Can I-
why this is so
can I just,
I know.
can I make a motion, or,
That we
I guess-
send it back to them to do it again.
yeah, right.
well, no, but I think the only change, and I think this language regarding the community associations, I think maybe in a few different areas, I can't recall. But if it is, then I think we should use the same, but it simply, if you take what's written and say, residents associations, business associations whose, strike out the rest and just say whose geographic boundaries are within
the-
200 feet of the
But
proposed development.
the problem, I think we tried that, and does the association have geographic boundaries, or its membership has the geographic boundaries, because the association is just an entity,
It's, Well, it's the physical community boundaries are
Right.
ultimately what you wanna get, and that's what I'm trying to get at,
Yeah,
not the,
I
the
know.
memberships too.
I agree with you, and we had that in, but, Alan objected to that too. How are you gonna define the geographic area?
Well, I
I
mean,
think
it's,
it's pretty clear. With community associations, that's abundantly clear.
Yeah.
Yeah.
It's
We
where the
have
community
subdivision
is.
layers. Sean does have subdivision layers, and we started down looking at this. The only quagmire in any of this is civic associations, and business associations.
Thanks,
And
Eastport.
and business associations, we have an idea on some of them. You know, we can, it's just, you know, those are the only ones that have a weird, could have a weird geographic boundary. So, you know, I'm just trying to move this along. I think geographic boundary works. The only way to get around this is saying you have, you know, is changing this and saying, if you want notification, you have to register with us, and then we'll just, I mean,
Right.
because there's a lot of people who, you know, when this thing got started, remember Crystal Springs affected the entire city, so everybody wanted to be notified, you know, the way
Yeah.
it's, the language read.
Still do.
That everybody would have to be notified, every business, you know, community association would have to be notified, so that's why we started honing this thing down to say, okay, within a geographic area of 200 feet, if your geographic boundary of your association lies within that, we would notify you.
That's where we started. I'm good with that.
And as long as everybody understands, there could be some hiccups along the way with not
Right.
notifying somebody, because we didn't know that that business association was incorporated into that.
So you're actually
That's fine.
expanding a little bit, because in the catchment area, if this is the project right here, I envision, let's just say this is ECA's boundaries, it would be in their catchment area. Now you're saying this is ECA boundaries, if you're within 200 feet anywhere along here, you're gonna get notified. So it's actually a bigger notification area.
Right.
Fine with me, the more the merrier.
Well-
Right, so, yeah, like I was saying before, if your community association is, and the project's over here, and the line, 200 feet catches one lot,
Yep.
we're notifying the community association in addition
Yep.
to the lot, in
Right.
addition to the homeowner.
Right.
So homeowners associations, condominium associations, and community associations all have a sort of defined boundary,
Mm-hmm.
because all of the lot owners, are, I mean, they are easily, you know, identified, I think. In a business association, and I guess a civic association, like Eastport Civic Association, is there a distinction there because they're not necessarily identifiable? Because they could be, you know, you could be a member of the Eastport Civic Association and live in West Annapolis, I guess.
No, but
That's why we're
Eastport-
saying geographic boundary, that's why I keep coming
No,
back to
you
the idea.
cannot.
You cannot?
You absolutely cannot.
You must live in-
Eastport Civic,
Why wouldn't we separate the business associations out from this group?
That's what I was leading to,
Yeah,
because they're,
because their standards are different.
yeah.
Community associations have boundaries, because it's the community.
Yeah.
Business associations like SoFro, not so much. So why wouldn't we treat
They
them?
have a defined boundary.
Okay, so maybe that's not a good example.
Well,
ECA,
EBA.
EBA.
has- Yeah, they have, you have to live basically in Eastport business areas. I mean, be a business in the Eastport area.
Okay, what if we just simplify it to say,
Yeah,
Well,
those
what's,
are-
what
what's
if-
So
different? There's
just like, all right,
something
here's-
different here.
No,
Well,
think about it.
suggestion.
You can identify a condominium building, you know where it is, so that's a condominium association.
Yeah,
In Eastport for business, you can identify the business areas in Eastport, 4th Street, 2nd Street, Severn Avenue,
so the
Sixth
shopping center is not part of it?
well,
no, the
I
shopping
mean,
center is part of
can I
it.
can I jump in
Dan
here
Letterberg is
between you two
member-
for a
he
minute?
was an officer.
Because
Okay.
I think if the suggestion about, if we use something similar to the catchment basin, whatever you wanna call it, right?
Geographic area.
We can, in the definition, we could
Now
say,
we're combining.
we can say in the definition that for community associations, homeowners, whatever the other thing that you had listed, the catch basin for those is considered to be the geographic boundaries, right? We can say for civic associations, which would be Parole, I assume, Eastport, and for Parole, we can say the catch basins will be perhaps even larger, right? Because what I'm thinking is for Eastport, instead of Eastport Civic Association, we can't define that other than just Eastport, right? So why can't we just create that pool larger? They're going to get a lot of notifications, but that may just have to be what happens for the civic associations and business
No, the
associations.
civic association does have a defined boundary. So what civic groups do you have in your ward? And do they not have a defined boundary for their membership?
I don't have that.
You don't have any civic association?
I don't have any either.
This is just
You're
your problem.
un-American. You're un-American. Well, good, then we'll just limit this to Ward 8 and notify everybody in Ward 8 of any project in Ward 8 and we're
West
done.
Annapolis.
No, do you wanna use that for your
West
boundary?
Annapolis does.
Is that giving
Ward
a catch
3
basin?
Parole
Parole,
does.
Greater
Eastport
Parole,
does.
Parole, yeah, right.
What else?
Did you say Parole?
I
Yeah.
said Parole,
How about
West
Ward 2?
Annapolis,
West Annapolis,
Yeah, West
Eastport.
Eastport.
Ward 1,
Liberty along
doesn't Ward
Forest
1 have
Drive.
a business
Well,
association?
you have the Ward 1 Residents Association. and
Well,
then-
they
Not a
used to
business, well, you've got
No,
the
you get the
downtown.
Downtown Annapolis Partnership.
Right, yeah.
That's not
Okay.
civic association. Ward 1 would probably
See,
fall in the
it's
category of
because-
civic association.
Okay, so,
Yeah.
But that's
And
all of
Parole
Ward 1.
doesn't Parole have some
Yeah.
business associations?
yeah, I said
Rural.
Ward
Yeah.
3, those are
So
the
all
three.
of the real city wards, 1, 2, 3,
Well, you know what, then
and
this
8.
is your problem, we're not dealing with it, let's go on. You figure it out. We don't have to deal with it,
Well,
because they ain't our problem.
I mean, it's
Just saying.
self-solving, because if you don't have any business associations or civic associations, there's no notification requirement other than people within 200 feet of the project.
So just,
So in Ward 4, if there are none of these kinds of entities,
Actually, I think, there may be a small business association at, I can't think of the street, where CBS is.
South Cherry
South
Road?
Cherry. They were working on forming, I don't know,
Yeah.
they're part of SOFRO, but,
The SOPO's in both
If you don't
waters.
exist, we
yeah,
can't
they go
notify you.
5 wards, if I
We're really
remember
just
correctly.
stuck on
Because
the
that's where,
mailing
but that's where you
address
could say
term, right?
Yeah, the mailing
the
address,
catch
I think,
basin
needs to be
for
changed to the
SOFO would
envelope.
be
That's what we're stuck on.
anything
so-
along 200 feet off of, I don't know, Forest Drive, I mean,
Right.
I don't know.
Okay, so
So
how are we gonna
200
fix
feet.
this?
So, I mean, Rob, you're
I would say,
suggesting within
the
200.
simple fix is geographic boundary within 200 feet. Change mailing address to geographic boundary, and
Right.
I feel like that's pretty,
Yeah, I think, yeah, because I mean, I
Simplified.
think Pete's staff can figure out that, which ones
Boundary.
Eastport
Yeah,
Civic Association should get notified
No.
about.
Okay,
Geographic boundaries
we might miss
of-
one or two, that's all I
well, you gotta
worry
take it back
about,
to
but
Alan, too.
It's in the mayor's office.
Take it.
Yeah, that's right.
So geographic boundaries,
Of the proposed, 200 feet
Of the proposed project.
of the proposed project,
Right.
okay.
whose geographic boundaries lie within 200
That one
feet
is
of the
either
proposed
this
development.
or catchment area, so,
Okay, so is that all of
oh no,
the
there's
Second
footnotes.
Amendment?
Oh, the Second Amendment, yeah.
Yeah, well,
I think so, so
Is that,
we have the normal process where a major site project comes in and we have people get notified, including the aldermen and so forth. And then we have the specific meeting for, this, community meeting pre-application. And we're consistent across all of those, right? And there's nothing that's getting dropped out like there was in an earlier version?
So we changed the threshold to if they have a certificate of value, it's not just every major site design. So
Right.
they're required to
I'm
have
still
a
uncomfortable about this,
pre-application
by the
meeting,
way, but
and then
we
they
still-
have to go, they do their community input meeting, so.
Right.
And then before they submit their application, they have to submit a community input
Bless you.
meeting.
Right. So any meeting you're holding, whether it's a pre-application community meeting or you're holding some other kind of meeting, it's gonna follow the same set of rules and the same notification requirements.
Correct.
That's what we want.
okay, so,
Trying to think, why are you asking that question?
Yeah, that's the
Can
goal,
I-
obviously.
Because I
Yeah.
think in an earlier version, Rob noticed that aldermen were, the aldermen being notified of regular things had gotten dropped out.
Correct.
They put it back
It's
in.
in, it's in,
Fix that,
Right.
yeah.
it's in
Okay,
here.
right.
Can I make a
Yeah,
motion
Rob?
to adopt Amendment 2 as amended by the committee?
Yeah, we would just take out, the words mailing address and substitute that with whose geographic boundaries lie within.
But now, don't you have to go back to Alan and know what the court order
Yes,
says?
yes, we do. But I
Well, you
think,
don't
but
have
the
to.
final,
That's what the court order says.
The quarter says we have to collaborate with him.
We
and It
do.
says it has to be mutually agreed upon in terms of what was introduced.
right,
But what ultimately gets passed is up to the council.
Well, yeah,
That's
but
correct.
I
So
don't
I'm not
think we
saying
should-
that we shouldn't try to collaborate, but I think if he wants to get this on the 24th agenda, I think he'll be amenable to.
well,
Well,
we actually have a.
we're gonna
court-
have another meeting, so,
Yeah, we have a court-ordered mediation in the litigation on September 27th, which we would like to avoid because it involves the expenditure of money to pay the mediator. So, I'm gonna run this by Alan, quick,
okay, and then
And-
you, can
and
you
we'll-
bring it back?
and we will, I mean, what I would recommend to the committee right now is to vote on, with a motion, obviously, in a second, but to vote on the amendment that would eliminate the words mailing address is, so 3 words come out, mailing address is, and we substitute whose geographic boundaries lie within, and then you already have the word within there. It's as simple as that.
I'm not gonna beat this dead horse, but I'm not seeing where mailing address, which one of these is mailing address?
Okay, so let's see, it's, if you look at,
Which lines, 31 through
let me
46?
see what you're looking at.
Yeah,
I'm
in the
looking
ori-
at the amendments.
Yeah, but that's,
Yeah, the amendments have changed. This is
yeah,
a
I think you
change.
gotta look at,
This is the new one, isn't it?
No. No, those are the old
Those are the
amendments that the old 2 that we had to change.
here, if you look at this.
Okay, I got that,
Okay, with the draft that was prepared. If you look at line, 42.
Page 6,
Page 5, line 42. And-
okay.
And so this document already incorporates the amendments that have been approved by the committee.
This
This
is something,
document isn't a real document, so how can
Yeah,
you
we're
amend
just
it?
I'm just trying to,
Okay.
give,
I just wanna
okay,
make
we
sure.
need
Alderman
the
some
amendment, we need to be
perspective.
clear on what amendment is.
Right.
This
Yeah.
is the document with stuff
we're just
incorporated.
using this so you can actually see the language. I realize that this is, we're looking at a draft, but this language is already in the last version of what Alan, Pete, and I have given to.
Gary, when I present this to the full council, I need the amendments listed
Right.
separately, because she's gotta attach them
So what
to
we,
the document,
So-
not embedded in.
Yeah, so do you have this document with you, which is titled 01418 Amendments to the Development?
That's that.
She has
right,
the old
it's 9
version.
pages.
Okay, so
And you go to page
That's not line number.
3,
it's not line number.
So
but
this is the one
it's
that Arnett's written in his name. Is this the correct one? No, that's not it
No.
either.
No.
Th-
There it
It's
is.
this
Could I have
9
that
pages.
copy right there?
Yeah.
Isn't
So,
that it?
when Jacqueline will put
is
the
it 9
line numbers
pages?
in.
Yes.
like that.
yeah.
Okay,
All right.
so on this document,
And that document,
Amendment 2,
Amendment 2, what we don't have is Pete's rewrite of Amendment 2 in
Page-
hard copy.
page 4,
No, it's in, that's what this amendment
page
is.
4 of 9,
amendment?
4 of
It's in
9,
this
4 of
Yeah.
9, that's the one in your hand.
That's the one. Right.
Page
Okay.
4 of 9.
4 of 9. And it says page 6, lines 26 through 46.
Yes, correct.
The applicant shall send written notification to.
Yes, that's the one. This is the way it currently reads after Pete, Allen, and I had, discussed the revisions.
I'm not
That's still the
seeing-
wrong version.
I'm not
Yeah, I
saying.
know, it's still
That's the
wrong.
old version.
Yeah.
I think
Well,
both.
then we don't have the new version.
We don't have.
Alderman, I think you need to look at the one on your iPad for the most up to date.
Well, this says 4 of 9 also, so why is this different? This is-
That looks different than the one I'm looking at online.
This is the same.
No, because there's no number 2 in the new. Well, not until you get to the next page.
So I'm looking on my
See, there's
iPad.
no number 2 on this, it's just number 1.
Okay, let's,
Applicants shall send written notifications.
right, and that's what this says. All parties, property owners, alderpersons, all, okay. So that's when, then it goes down to persons, no?
Yeah.
No, then it jumps down to persons other than city staff who have, so D and E are not in
You're
the
looking
written
at-
document.
That's an old one, and this is the most current, up to date. This is the one that Gary sent out to everybody a few weeks ago, and the one that Alan High mailed to us, a hard copy of.
Okay,
But I can't find, this is so hard to look at. I can't find where this mailing address is in this Granicus version.
It's in number 4, or D. Sorry.
1D.
So right here, mailing, associations whose mailing address is within
Okay.
200.
All right.
let me tell you, if we can't figure this out sitting here,
Oh, and yeah, the council's never gonna know. They're never gonna be able to.
I think, so what you do, what you need in order to go forward with a motion right now is a page number and a line number, so that you can identify where the change is taking place,
Right.
then you're
okay?
gonna have to give
So
them
we're
to
gonna
us,
have-
cause
yeah.
I don't see them.
So we are gonna have to, we'll have to get this revised stuff that's in Granicus to have line numbers, right?
Well,
Well,
Well, it does have
I
line.
think Gary, you understand, I think, the direction
oh,
we
sure.
want to go with amendments. So
Yeah.
if we're meeting next week, maybe you can check with Alan High and then
Sure.
get us the actual updated paper.
Mm-hmm,
Yeah.
Get us the actual updated paper version, and then we can vote on it then.
okay.
Is that okay?
Yeah,
Madam
sure.
Chair?
Yeah, that's fine,
it's good
and
with
you
me.
can send it electronically, I mean, I don't have a problem with that. But we just need to be on one document, cause we've
Yeah.
got too many
Oh,
documents
I
here.
know.
Yeah, we do.
And-
Well, maybe
Um,
put the date on the top or something,
Sure.
or drafted, or,
I mean,
That'd be
what I'll do is take the last document that was sent to you, with the most current revisions, with, page numbers and line numbers, and then you'll be able to see which words are being struck. I'll work with Jacqueline on it.
Yeah,
Which words are being struck and what's being replaced.
okay.
And, I mean, what are the replacement words?
We don't want, I know the alderman does, but I don't
Yeah.
want a clean one with everything already embedded in it.
Yeah.
Because I
no, but
can't figure it out.
that was very helpful for me to be able to go through and get the whole flow.
Okay, but we'll work with the most recent
Okay,
revisions, which I know I sent to you, a few weeks ago, something like that. And we will work within that email
okay,
and give you, what the amendment would be, line number, page number. And we'll have that for you whenever the next meeting is.
I think Rob just mentioned, dates on documents, and this is for everything. I think it would be appropriate to say revised on and put the date so you can see which is the most recent, on every document, not just this one, but I think that would be very helpful.
Yeah, well, I'll talk with Jacqueline and Rich about that one.
Yeah.
I think it's a good idea too.
So there's a couple of other problems. So going back to the original, legislation and going to page
Are you on
7.
9 of 9?
No, I'm in the original, this,
Okay, so you're in
the-
original
what was
legislation.
originally submitted. And I'm on page 7, which has, at the top of the page, an F,
Right.
which all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application, which list of persons shall be provided by the Department of Planning and Zoning to the applicant. I don't understand what that's saying. And then we've kept that in but added a G, which I have no idea where you find the G. And the G says, in case of a required community meeting, comma, caused to be published, comma, in a newspaper of general circulation at least 15 days before the community meeting notification of such meeting.
Is that was moved from someplace else, wasn't it?
I know, but is it,
Added.
so let's see. If I start with F, the applicant shall send written notification to all persons other than city staff who have provided written comments to the department regarding the application, which list of persons shall be provided by the Department of Planning and Zoning to the applicant with 5 days of the application's written request of such list. I mean, it doesn't really read like complete sentence or a complete thought.
Well, I mean, let's just look at it logically. When the application is under review, posted, department gets comments from the general public on some of these applications, and so it is clear who has, we get emails essentially. I think it's in the form of emails mostly, and
So this is left over from,
yeah,
this is what's currently in the, was prior to 035. We were to provide written comments that we had received whenever we posted a property.
yeah.
All right, so let
Well,
me test though.
I have a question on
When
that.
you read this, B number 1, the applicant shall send written notification to, semicolon, and then all parties, A, property owners, C, the alderman, D, the president. Then you get to E, all persons who have spoken, then F, all persons other than city staff who have provided written comments to the Department of Planning and Zoning, which list of persons shall be provided by the Department of Planning and Zoning to the applicant within 5 business days following the applicant's written request for such list. It doesn't read like a sentence, and when you go to G, you go back to
Well,
1.
before you go back to leave that.
Right.
So what is it what's the intent?
I don't know.
The people who, and that's what I'm asking, not you, I'm asking Pete and Gary. All persons who have provided written comment, what happens? What will they do?
See,
What
the
is the
applicant-
expectation? Because then it goes on to talk about a list of persons shall be provided to
So-
them, to
Yeah.
whom?
So it starts with, the applicant shall send written notification to all persons other than city staff, I don't know why that's in there, who have provided written comments to the Department of Planning and Zoning regarding the application. I'm clear so far. Then,
Okay.
which list of persons shall be provided by the Department of Planning and Zoning to the applicant within 5 days following the applicant's written request for such list? There's too many parenthetical
Okay,
expressions.
Pete, do you
but I
understand what
can't
that
fig-
means?
So I think the combination of two things were going on that we're trying to identify. The list of people that attended a community meeting are to be contacted by the applicant when they submit their application. So I think two things are what that happened here. So what originally, and I think 035 or prior to that was, we have to provide them the list of anybody who has made written comments to us if we provided to them when they have the community meeting, or if they have the community meeting.
So why can't we just say that?
That's the second part. The first part is that when a property is posted, we get written comments from anybody and everybody, and and we provide that to the applicant as well.
Mhm.
So there's two things that are going on
So I
here.
actually think F should be split into two things.
Well,
Because it's that parenthetical, which list of persons shall be provided.
what I'm gathering is anybody other than, who's not city staff, but anybody who makes a written comment, then the list of all of those people who made the written comment must go to the developer.
Right, they must be notified about their application once an application, yeah.
But it's the
Okay.
list of people who made the comments, right? And that list is generated by the planning department
Right.
So,
within 5 days.
yeah, so do you understand what I'm confused by it, the
Yeah.
construction. Maybe that which, list should just be in parentheses. You know, or a note, maybe it should be a footnote even. So it would say, it would start off, the applicant shall send written notification to all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application.
Period.
Period.
Then there's a footnote for some parenthetical expression, put it in, parentheses. Note, the list of persons shall be provided by the Department of Planning and Zoning.
To
Within-
the applicant.
To the applicant, within 5 days.
Right.
I don't like
Following.
that. I don't like the within 5 business days. Just as someone, as a
That-
former staff person, and current government employee, I don't like, I mean, there are
Well,
things
okay,
that
if
comes
you wanna
up, there are
change the
big
number of
projects
days,
that
That's
are
fine,
gonna
but I think
take
this
staff's
is,
time. I
as
think that
Pete
just
said,
pigeonholes
Well,
them too much.
but-
That was an
how
Allen
is-
amendment, I can tell you, putting the time constraints on the staff to get it back after the request is made, once the request is made.
Right.
But how are the written comments generated? I mean, do you just make copies of all the written comments and give
they're
them to them?
posted on Granicus.
Yeah.
I mean, on,
Track
Tracker.
it.
Mhm.
Okay.
So yeah, that's what we were like, depending upon the project, we typically, I just try to load them up as soon as we get them, but sometimes we don't, we wait. Different planners have different ways of doing it, they wait till they were still, till the end of the comment period, then they load them up. All at once.
See,
So how
I would end,
taxing is that? I mean, I like deadlines. You know, people accuse us of taking too long to do everything. So is 10 days too short a window, you know?
I just think staff
Or
needs to
5
have
days.
flexibility, because you don't know what their workload is. We know most of them are
Right.
overworked. They need to be able to set their own priorities based on their own department needs and not on the needs of
Well, two
particular.
thoughts come
How
to
about
mind.
this?
5 days is a short period of time. I agree with Rob there. I think, you know, sometimes there's no way you're gonna get anything written in 5 days because of other commitments you've got going on related to work. But
Or
the other thing
hurricane.
is there's no consequences here of providing, you know, say it's
Yeah.
10 days instead of 5 days. What's the consequence? There really isn't any.
So why even put it in if
Well,
there's,
Teresa's
Pete, your
gonna start
department-
firing people.
should we put it
What
in
do
the
you
code
think?
if there's no actual
I think
consequence?
when it's brought, yeah, it is interesting, I thought I had an idea of what this meant, but now as you break apart the sentence, I'm confused myself.
I think
But
it
anyways,
just-
the
in the-
5 days wasn't a big deal because it's after their request.
Right.
It's, I don't have to worry about,
Mhm.
has the comment period, and you requested it, I'll get it to you in 5 days. And it's like I said, like we
Okay.
said, we load it up anyways, it's just printing the stuff off and
Yeah.
saying, here it is.
Mhm.
I would end the
So,
sentence, Pete, I would end it after regarding the application, period. I would start a new sentence, which is an information-giving sentence. The list of persons shall be provided by the Department of Planning and Zoning to the applicant within 5 business days, or how many days we want, of the applicant's
fine.
written request.
Yes.
But
Make
for
it- make it as
clarity,
part of the applicant has to request it,
Right,
yeah.
because they don't all ask for it.
so I actually think putting it in parentheses, but it is giving information, but
Well, it's a separate sentence
yeah, it
there
is
too,
a separate
so.
sentence, right.
And I would
if,
say the list of persons who have provided written comment. And I know that sounds repetitive, but I think for clarity's sake, it would be.
Okay.
But now G, you go back to the beginning,
Can-
the
b-
applicant.
Before you finish, before I go on, and then I would add, provided, shall be provided,
You read all this stuff?
comma, by the planning and zoning, comma, to the applicant within 5 business days.
Where did you want the comma?
The list of persons shall be provided, comma, by the Department of Planning and Zoning, comma, to the applicant
Okay.
within 5 business days
Yeah.
following the applicant's
Right.
written request.
So do you think
Just for
it,
clarity.
do you think it's clear that, this is only something that needs to be done by planning and zoning if they get the request from the applicant?
Who else would do it?
Yeah, I'm just saying that, just wanted to make sure everybody's clear on that.
Unless the mayor reorganizes city government again, and then we're,
Key?
So then, going back, we start again, the applicant shall send written notification to, and then G starts, in the case of required community. I mean, it doesn't flow from the colon. So and again, I'm not really clear what it is, because this is all a list of things that the applicant shall be sending. So what are they sending in G?
The newspaper
That I
posted.
think we discussed that as maybe being, last time, a separate, separate paragraph, because I agree with Ross right there.
So that could become 2?
It could be, we could renumber right there, start
Right.
renumbering. And,
so G becomes 2,
Yeah.
Yeah.
and 2
Yeah.
becomes 3, and
right,
Well, what would,
So then the new 2 is, in the case of a required community meeting, cause to be published in Pren's
the
in a
applicant,
newspaper.
we have to say the applicant shall cause.
The applicant shall cause to be published in a newspaper of general circulation in the city. See, it's not a complete sentence.
Well, you can just say, in the case of a required community meeting, the applicant shall cause to be published notification of such meeting in a newspaper. I think notification of
what's
such
it
meeting,
mean, cause to be published?
they have to do it.
Okay, so they
They
have to do it,
depend-
just say they have,
Therefore,
must
hereto,
publish.
hence.
Huh?
Damn attorneys, therefore, hence,
Yeah.
In the case of
Henceforth.
required meeting,
henceforth,
the
Okay.
applicant must publish in a newspaper of
applicant
general
must publish,
circulation in the city, which should be capitalized, at least 15 days before the community meeting
Right.
notification. The,
Yeah,
notification of a community meeting must be published in a newspaper of general circulation in the city at least 15 days before the community meeting.
Right,
there you go.
yeah.
That's
So,
common language.
I think
Yeah.
it would read, in the case of a required community meeting,
Notification,
Notification
of such meeting
must be
must be
published.
published in a newspaper of general circulation in the city, comma, at least 15 days before the community meeting. So it's
Mhm.
just reorganizing.
so
the
you don't
sentence.
want to say that, make it clear that the applicant is the one that
Oh, no,
causes
you
it
can
to be
say that,
published,
yeah.
because we have this situation going on where there's a little controversy about what
Yes.
that actually means. I think
Right.
we need to say the applicant does it,
Yes.
Yeah.
at the applicant's
Mhm.
expense.
Mhm. The applicant
Doesn't it
must
start off with
publish.
the applicant?
The applicant must publish.
So, I only have 2 other things, and really only one. When we go to the table.
Okay, are we finished with that? So we're
Yeah.
rewording that, and that G becomes 2, and then all the other numbers and
It'll
letters,
get
well, at
left
least
out. Yeah.
2, 3, 4. Doesn't impact C. Okay, next.
So on the public meeting table, which is on 7 of the draft, going down to major site design, the PH, public hearing, footnote 2 says, a site design plan associated with a proposed special exception shall not be considered by the planning commission and shall be decided by the planning director. What is that and why is that?
So that's when you would get whammied with both a special exception and a certificate of adequacy, and what we're saying, instead of having to go both to the Board of Appeals and a special exception, the planning director would make a recommendation that it met the findings of the site design to the Board of Appeals, and the Board of Appeals would actually make the final decision on that application. So it's to stop a dual process, or not
Well,
stop.
first of all, I want to go back to the dual process. I think we made a big screw up. I think
yeah,
Chuck
I second that.
really flim-flammed us on that, because the 2 bodies hear very different kinds of things, both of which are important. But setting that aside, and it's coming, so be prepared.
But we're giving the authority to the planning director.
Well,
Right.
not really. The Board of Appeals
Board
would
of
make the final
Appeals, yeah.
decision. It's just, in
Board
the
of
way
Appeals
it's
has
structured.
never made,
The planning commission has to make a final decision on a major site design, let's just say. But prior to that, or the issue is when, you know, do you get the variance first, or do you get the special exception first? Is it a chicken and egg thing, or does the planning commission? So, the way it's structured without that footnote, a site design would have to go to the planning commission, and it would go to, if it was a special exception, it would have to go to the Board of Appeals. What this is saying is that if it has a special exception, it would only go to the Board of Appeals, and I would make the decision on the site design. There would still be transparency, there would still be a public hearing on the project, including site design criteria.
So, give us an example.
So it won't go to the planning commission, it'll just go to the Board of Appeals
So-
and to Pete.
To give you an example, is a daycare center. A daycare center would be something that would, you know, probably generate a certificate of adequacy, would fall under Title 22 because it generates more than 250 trips, let's just say. It would have to go to the, and depending upon the, it's in a R2 zoning classification, it's a special exception. So it would have to first, well, this is the argument, since even among staff, in my opinion, and Gary's, I think follows, it would first have to get the use has to get approved by the Board of Appeals, and then it would also have to go to the Planning Commission for site design based on all of this. We're not saying it doesn't have a community input meeting, it still meets the criteria of the community input meeting, but because it's going to the Board of Appeals, it doesn't have to go to the Planning Commission. Right now, all major site designs that qualify for Title 22 have to go to the Planning Commission. I no longer have that authority for every major site design, just some.
Okay, let me ask a question then. Let's say my church wants to have a daycare. What's the process?
On
Well,
Second Street.
that
in
would
Eastport.
be.
On Second Street in Eastport.
Depends, because depending on zoning classification is. So you have churches with daycares, that is a specific use. Let's just say it's a special exception. You wanna add that daycare to that use, you now become not just a place of worship, you are now a place of worship with a daycare. So that use, and I don't know if it is, but let's just say it's a special exception, if it meets the criteria, depending upon its size of needing a certificate of adequacy, it would have to go to the Planning Commission and the Board of Appeals in order to get approval. And a community input meeting. It would start with a community input meeting, and go through agency review, it would get on the Planning Commissions, and it was also get on the Board of Appeals agenda, and they would have to track that process, which could be months. I mean, just to get onto the Board of Appeals, and then it could be additional months before they heard it and got on
Right,
their agenda.
but the special exception is about the use. If they're building a new daycare center, if they have the room and they're building one,
You mean adding on to an
Adding on,
existing
yeah.
building?
that is different, that has site design implications, and it'll have impact potentially on neighbors. Let's suppose this is going to be a two-story building in the backyard that's gonna abut a whole bunch of residential buildings. I mean, I think that is, I mean, this
Still
has
have
to
a
be big
community
enough.
input meeting, I'm just saying it wouldn't go through in site design review. It would still go to community input. It just, if it's a special exception, it would go straight to the Board of Appeals, it would bypass the Planning Commission process and getting on their agenda. Site design would be a decision by the planning and zoning director, but the ultimate decision would be the Board of Appeals, because I have to make a finding that it met the site design criteria before the Board of Appeals
But the
would
Board of
consider.
Appeals never looks at site design stuff, they're only looking at, is it in the code, yes or no?
You still have your community input meeting.
Does the code follow, yes or no?
I mean, true, but they, you know, they do get a little bit into site design, but mostly they do look at the criteria for the
Right,
special
so the
exception.
whole thrust of this is big projects, however we define it, major site design or it needs Title 22 certification, are the ones that are gonna have community impact. So now we have the public hearing before they can even apply, but the whole thrust that Joe and I had was, when these are big projects, we want them to go to the planning commission for a public hearing, at the planning commission, instead of being negotiated inside the planning and zoning department with Tom Smith or Kevin, whomever. That was the whole point, was that these things would be heard in public, where the public gets to weigh in like you do at the planning commission. So this cuts out one of the things that we were specifically, Joe and I, specifically trying to get before the planning commission.
But we do have a community meeting.
But the community meeting is just to talk about the concept. You know,
Nothing
here's the
binding on
building,
that.
here's what we're
Well,
gonna do, we meet the
neither is the
checklist.
planning commission.
Well,
Pardon?
planning commission could put conditions on it.
Yeah, they can put conditions on it, or deny it.
Yeah.
Uh-oh.
Oh, what are you here for? Are we
They have a meeting, HPC.
at 6?
Oh, well, I need to go to
Seven.
that.
Seven.
What, that's a,
Oh.
what's going on at that meeting? It's important.
Lots of stuff.
All right,
Cultural
well,
landscapes.
I need more time to think about that. But, there's
Well, you
footnote.
have a week.
Yeah,
I tend to
footnote
agree with
one.
you, Alderman.
Pardon?
I tend to agree with you on that.
Yeah, I mean, it's kind of pulling back from what we were trying to accomplish in 3517. So, you know, and I understand where you're coming from. It extends the period of time for the developer. That's great. I understand that, and time is money. On the other hand, when you put a project in that the community doesn't feel like they've had input on, their time is forevermore. You know, developer's time is measured in years or months. The community has to look at that from now on. We have to look at the sale law from now on.
Okay.
And so that's.
I'm not arguing with you, I'm telling you what
No,
the
no.
process
Well, I'm just
was.
saying, I'm not sure I like footnote 2.
So do you wanna come up with an amendment for footnote
Well, I
2
would
for
drop
the next
footnote
meeting?
2, period.
You
They
gotta,
have to go
Pete's
through the
gotta
most.
agree, I mean, his department, this is his.
No, I know,
It's a
but
policy decision, it is, again, resource, it's an issue of resource, you know, another night out with staff and and a delay in the, you know.
Staff needs to stop
Well-
coming into work during the day when they got nights out, I'm just saying.
well.
I'll see you next week then.
No,
Cause I got
no.
3, potentially 4
What
nights
they-
this week.
What they need is more staff, like the
I
finance
don't-
committee tried to get for them.
I'm just saying, you're right,
It was the
you know,
G4 that
no.
took that staff away.
Okay, well, you can't have it both ways, you can't
So
have,
I was
give them more
only
work
in
and then
agreement
take-
with Mr.
don't
Hyatt
give them
because I
staff.
looked at it as a resource issue. It's another, you know, it's another night, an evening that somebody has to spend. Okay, and now I'm being selfish about this, and that the community's value, you know, process is valued. But you know, also they would have 2 shots at it in terms of, and I know what you're saying about the Board of Appeals, but they do take into consideration the community's concerns and thoughts and ideas.
They
So
really don't, and I've heard them say, that's not in our purview, that's a site design issue. And,
okay, I've heard them say it differently, but okay.
well, okay, but I
Well-
mean, the point is, the whole thrust of this is, the community gets a big project that is well down the road before they're even aware of it. Now, I know, I've been seeing email that some people are just now realizing that something is going on in the Eastport Shopping Center, and they said that at the community.
I got a better one. Somebody just learned about Parkside Preserve. What? That's
they've
doing
been
what?
under a rock for the last 10 years.
Yeah, I know.
Mhm.
I
But
just
the
learned that
whole
there's a
point
development
was
going
to
on
try
right here
to-
on the left. I was like,
What
Yeah.
we wanted to be able to say to them is, look,
They've been calling you
to
too?
our constituents, because they bite our butt just as much as they do your staff. We had this hearing, it was published. The developer, before they ever talked to the staff about any, can we do this, can we do that, had to let you know that this project was coming down the road, give you what the nature of that project is, how big it's gonna be, how spread out it's gonna be, and they had to follow a checklist that was a checklist that this planning and zoning uses. And so that's the whole thrust of this, and then this could be shortcutting, I don't know. I mean, that's why I'm worried about footnote 2. Some projects that have that aspect, so now we've made the community aware of it, and they can send their comments into planning and zoning, but they don't get to participate in a public forum about the decision being made.
Well,
I can tell you, having sat with the Board of Appeals for a lot of years and the Planning Commission for some years, that the Planning Commission is much more tuned into site design than the Board of Appeals.
Yeah.
Much more.
And to community
Yeah.
input, which
Yeah.
is one of the reasons why developers don't like the planning commission and don't wanna go there.
So
And part
Ross,
of that's because they have no idea what's gonna come out of it.
are you making a motion to strike that footnote too?
Well, I'm
Or are you gonna think
talking
about
about
it
it
some
now. Look, I'm a policymaker. I do policy 2 or 3 times a week. You do this stuff every day as a professional for a living. So I don't wanna be an ogre and say, no, that's what we want. But I am telling you what my feeling is about that footnote too. So I'd like it, go back and talk to the staff and come back. I don't wanna be a jerk.
Well, that's what was
Okay.
done before, right?
Pardon?
But this was done before.
Well, and the staff offered that footnote too, I think I got from you, from the discussions. I'm saying I'm not so comfortable with that. I get it about the resources, both for the developer and for the staff.
You know,
Get it.
one thing I can say is that, Pete just reminded me that that footnote came from Alan Hyatt, and that footnote does not deal with an issue that is involved in the litigation.
Right.
He did not raise this issue in the
No,
litigation.
I know.
He has that in there, and all along we've been talking about, let's confine this to the issues that are involved in the litigation, and then some other ordinance can take care of whatever else either the council wants to take care of or him, meaning Alan.
I remember him saying that about one of my proposed amendments.
Yeah, right.
Well,
Well,
yeah.
then
Yeah, right.
we can
There you go.
simply strike it. I mean,
Yeah.
if you wanna amend it out, we can do that.
Well,
It's not part
as
of
I
the,
say,
Well, I think that the
Yeah,
logic.
I get where you're coming from, Ron.
Okay.
Again, I just, I agreed with it only because of the resource issue, but if you see the value in the community, we originally with 035, we talked about this and why we got into the arguments of, should it go to the Board of Appeals first and then the Planning Commission? And because of their schedules and their timing and all that stuff, I think we've worked out is that we'll do whatever comes first. So if the Planning Commission makes a decision on one way, we'll let the Board of Appeals know what their decision was if that has an impact. Or vice versa. The Board of Appeals makes a decision, we let the Planning Commission know what their decision was, and hopefully it gets worked out without having to go back to the
I
Planning
think what you
Commission.
said before, I mean, the use has to be approved before you can go anywhere.
Well, the issue
on
is
this, and
that the
so-
timing of everything, they meet,
Mhm.
one meets the first Thursday, one meets the first Tuesday, it may not work out, and depending upon the agendas. That's why it was, we talked about this amendment, and I agree that that's a good idea to just have it go to one entity versus the other. But if you feel strongly about community input and the value of the community input, and it's not getting there, I'm okay, I'm
Okay.
not gonna.
Well, I
so,
brought it.
bottom line.
I don't like footnote 2.
Mhm.
So
Well, are
let's
you willing, do
move-
you want
Yeah.
to amend it to
I'll make
take
a-
it out,
Yeah.
is what I'm asking?
Yes, I do.
So is that a motion?
I make that motion.
Yeah, I'll second that.
Okay,
Okay.
further discussion? Last chance to weigh in. Gary?
Oh, my thought is that the planning, I'm concerned about bifurcating it into two, sessions, one with the Board of Appeals and one with the Planning Commission, because that's exactly what we've tried to avoid, ever since we made the change. But I'm also concerned that this does not, this language is not anything that was brought up in the litigation. And all along, as Rob said, we were telling Rob, let's confine it to litigation, so it works both ways. So I would recommend that it come out.
Okay.
I would recommend, but let me say, I resented Alan filing the restraining order and imposing himself into the legislative process, but frankly, I think it's led to better legislation. And just like Alex was saying, when they brought in the development community to be part of making the rules, I don't have a problem. I talk to Alan all the time. I'm talking to him about redefining major site design. I'm still talking to him about that, and I'm talking about 027 from the other nights. I don't have a problem talking to him, and I think even though he overstepped some of the stuff from the court order, if it makes for better legislation, I'm not gonna quibble about that.
Okay, I'm calling the question.
Yeah, no, okay,
So motion on the
Aye.
floor
Aye.
to remove number 2 on
Footnote
page
two.
8 under the the chart.
Right.
All in favor, please say aye.
Aye.
Okay. So,
footnote
do you
one.
get that, Takia? So that's a,
I
rules
just
committee.
need help understanding footnote one. So it's subdivisions, and it, goes to a public hearing under the planning commission column. Why does that need a footnote?
Because this is in Title 21 and subdivision is Title 20.
Yeah.
Yeah.
Yeah, why did we have 20, 21, and 22?
Well, here we go with that.
Okay, that's not a question we can solve tonight. Okay, so you're going to go back and rework the Second Amendment, the Second Amendment,
Madam,
Amendment number 2, and bring it back to the
Bear arms.
committee at next week's meeting,
Right.
correct?
I
Yeah.
did have another amendment.
Oh,
I know, I hate to spring this on you.
And we do have another piece of legislation.
Yeah.
not today.
So this would be, what would that be, my proposed Fifth Amendment? I'll
Keep
have enough for
passing.
both of you, but, so this would, change section 2,
Oh, sorry.
this changed section 2 on the last page. It basically changes the applicability. And I tend to favor things that apply to projects that are in the pipeline. So if they already have approval, I'm okay exempting them, but I think this should apply to anybody who's submitted an application who's not gotten approval. The way legislation is currently written is that anybody who's already submitted an application, as we know, it could be many years before an application is actually completed, and they would still not have to comply with these new standards. So I think that they should have to comply with the new public hearing standards unless they have an approved.
I think that's, I know you know that's something that you like, because I've seen it in other legislation. But the problem there is that, you know, someone could be within a week or two or three weeks of, you know, they have filed their application and they're so close to getting it approved, and they've spent 2-3 years trying to get that approved, and then all of a sudden the law gets changed on them. I'm not even sure that we could defend that, you know, because there's something called detrimental reliance in law, and if you rely on something to your detriment, and usually the detriment is spending a lot of money, and you rely in good faith on it, and then all of a sudden it's turned on you, and you've gone so far and you're so close to getting approval that, you know, you could set someone back 2 years. We could get, my concern is that we could, you know, that's going to cost someone a lot of money, and they're going to go after the city, I think, you know, if we say, if Pete all of a sudden says, you know, you got to go back to ground zero, you know, it wouldn't surprise me if we wind up in a lawsuit over something like that. Just because
But I don't think that's why we should make policy.
Yeah, but
Well, no, but I have to
Yeah.
disagree though, because I
Yeah.
think the case law, we are a late vesting state, and case law has supported that in Maryland. I mean, this is coming from the Maryland Planning
right.
Administration, when they gave a presentation at the Maryland Municipal League about 2 planning commissioners and council, and they said specifically they've had planning commissions who've changed decisions of previous commissions. I mean,
Well,
they've had cities that have changed the rules even after permits were issued. This doesn't even go to that extreme, because again, Maryland law says unless you have something built in the ground, you have no vested interest.
Well, there's more than just vesting involved. There's this detrimental reliance concept that I've told you about, and you know.
But is there case law on that? Because I mean, the case
Yes,
law regarding
yes.
this has been held up.
Yes, you know, the city, it's called estoppel. It's a weird term, but it's called
But we've also used this standard before. We used this with the Forest Conservation Act, and we used something even more aggressive with the sediment control overhaul back in
Right.
2000.
Well, if you
2008.
can refer me to the case law, I'd like to read it, because I know what you're talking about when you mention vesting, but I'm also concerned about, you know, a situation where you have someone who spent $1 million over 2 years, and then all of a sudden the rules are changed on them. to me, is irrelevant in a
It's
situation
a
like this.
gamble they take in Maryland.
See,
though.
I
It's
think you're looking at the
Well-
wrong side of the equation.
Mhm.
To me, if it's important enough for the policymakers to change the rules, it's
Mhm.
important. And it seems to me that if you want to change the rules, you want to have the maximum applicability of that rule. I think
Well,
there are
I
matters
understand
of
the policy.
degrees here.
I understand the policy.
Yeah.
I don't disagree necessarily with the policy, but that's not the only thing you would consider in something like this. You gotta balance it out between policy and, um, this concept of what we call detrimental reliance. And so Maryland adopts that policy. I can research it a little bit more. I think you and I have discussed this already anyway. But we can come back in a week and I can, go through the vesting and the estoppel with you. We're gonna come back anyway, right?
Right.
Mhm.
So,
I can send you the case law
yeah,
I
would you-
have on
yeah, thanks.
vested interest.
This
Yeah, I mean,
feels
I've read my.
very
Mhm.
vindictive.
It's not-
Well, I'm just telling you, you just shared one side of it, and we as policy makers have that right to treat our citizenry, even though we don't agree with them, any way we want to. This looks as if it's a target on the backs of developers. We realize that. We understand that there is a effort afoot to stop everything in the city of Annapolis. And that's the reality. We can pretend it's not, but we know it is. Okay? We've gone around and around with forest conservation legislation on this same issue.
Right.
Okay? So to say that somebody has vested their time and their money in a project, whether we agree with it or not, it is unfair to create legislation when they went into the project with one understanding, and then we changed the rules in the middle of the game.
See, to me, that kind of argument has always ignored the other side of the equation. It's always in favor of the developer.
No,
If the policymakers
no.
have changed a policy, one needs to presume that they're doing it for a reason and that it is for a positive impact, and it is probably largely for the citizens.
Well, but see,
Not the
you're
developers.
making an
Not the
assumption.
developers.
You are making
No,
a
you
very
are.
bad assumption.
No,
Okay,
you
well,
are.
we're gonna agree to disagree on this
Right.
one. Because clearly, the target is just the opposite of what you're saying. The citizens do care, and they do care how businesses are treated in the city. They do
I'm not saying
care
they don't.
about how revenues are generated in the city. And I'm not gonna get into the alternative, okay? So anyway, we have a motion on the floor. Did you make a motion to? Okay, so are you just introducing this for the sake of introducing it, or is this a motion?
Well, it
To
will be
this
motioned.
Gary was gonna do some research.
Yeah, I'd rather.
Oh, okay, so this
if you
is
don't
gonna come
mind waiting
back
to-
to us on next week.
Yeah, I just wanna, make sure that I got the law fully researched.
Right.
Okay.
And then, you come back anyway next week and you could move it at that time.
Okay.
And
Yeah.
by the way, my view is, there's nothing wrong with going to court. I think going to court is a good thing. When you have gray areas, that's what courts are supposed to do, help hash that out.
That's true, but I just wanna make sure that I find it defensible, because,
Oh, yeah, no.
I don't wanna be in a position where I'm going into court and I, can't support the city's position.
And more importantly,
Yeah.
we want you to advise us
Mm-hmm,
with your best knowledge,
okay.
okay?
Mm-hmm.
And that's what we have to rely on. We don't have to agree, obviously, but some of us rely on.
Okay, well, I think that's it. I think we have a good, way to get to the next week, the next meeting.
Okay.
And, I'll come back with some,
Y'all come back.
more information. I'll come back.
Takia is, 019,
18.
18? Yes, sorry. Is that time sensitive, or can we come back to it next week? Okay. Then we need to set a date for the next meeting. And, would you tell Will that if he has his appointees to you by Thursday, they can go on the next agenda? Whenever that happens to be.
Carrie texted me and asked me if I could be at rules.
Yes, please.
What about the 18th?
That's the day the final goes out.
What goes out?
The final agenda goes out on the 18th, so it'll have to be prior to the 18th.
Can we just amend we might just need to amend the agenda if we can't fit it in, our meeting in on time.
Well, the agenda should be everything on it that we're gonna be dealing with. What do you mean amend the agenda at the meeting?
Yeah, well, I mean, can we just get this placed on the agenda and then we'll be able to get you the final documents on,
You mean we can
On
remove it
Thursday?
if we're, so we've gotta have it by the 18th?
Mm-hmm.
I don't think that's set in stone, that's the target. But if we
But
can't
if
meet
staff
till,
tells us that, I'm
No,
gonna go with,
She sends her final out on the
So-
18th.
I know, but we can always amend the agenda and get these documents added within, if only 48 hours notice.
I would prefer that we put it on the agenda, and if we don't address it, then we take it off. But I think we should put it on the agenda so the community has some expectation.
Right.
So,
I'm not arguing against that, I'm just saying we're restricted with when we can meet next week. As long as
so
we
what
meet
time is
by-
the council agenda meeting during the day, Takia? Is it in the
Well, the
morning?
agenda meets, they have their agenda meeting this Friday, but she sends out her final on
Actually, I
the
said
18th.
close of business. Sorry.
Close the business on the
But we
18th.
only need to provide 48 hours of notice.
An email, Diane.
So as long as we get them the final amendments by Thursday, Friday.
No, I can meet this
compliant.
Friday.
Yeah, she says you want
I don't
public
think
comment.
I can, but I might.
No, I see.
What about Thursday?
Does that give us enough time for notice?
It depends on what's,
No, we
when
don't.
is the room available next week?
And Monday, what about Monday?
Monday, I can't do the evening, I can do during the day.
Can we start earlier on Monday? 2 o'clock, 3 o'clock?
I have a 3:30. I could do before that, I suppose.
4 o'clock on Monday?
I can't do 4 o'clock,
Oh, you can't do Monday?
not at 4 o'clock.
9 o'clock?
I might be able to do like a 2 o'clock on Monday if you want to do that.
Okay. Is that gonna give us enough time?
I mean, Tuesday's
We
better
have-
for me. Do you have anything Tuesday?
Well, Tuesday is not gonna be in time for the agenda, final agenda to be struck for the council meeting. And I'm sorry, I know you don't agree with that,
I
but,
think our schedule should take precedent over this arbitrary deadline that staff sets.
well, it's not arbitrary.
It's
Well,
not.
okay, we're not
It's
gonna debate
not.
that.
But
Is
it's
it gonna
not-
hit?
Code-
Okay, how about
I
2
know,
o'clock
but it's
on
not
Monday?
code.
I-
Code is
I can do
Open
that.
Meetings
2 o'clock,
Act,
oh, you
48
can't do
hours.
Monday, 2
I can
o'clock?
do Monday at 2, I just
Okay,
can't do
let's do
Monday.
Monday at 2 o'clock.
Okay.
Gary, is that gonna give you time to? Okay,
What is the latest on the hurricane? Is it gonna give us a big surge?
It's still questionable, but yeah, they're looking at coastal flooding, the biggest issue. But on more normal.
well, City Dock's already closed, right? For all intents
I
and
can
purposes.
only
There's
meet
a-
for an hour and a half on,
Most of the miles are
hour
short,
15
sand,
minutes on
and
Monday at 2.
Well, can we go earlier? Because we have the 3 pieces of legislation that are coming back, plus we have, what, 8
Look,
appointments?
I'd have to take off work, but if we do it on Tuesday, I could do it without taking off work. They lose maybe a day of notice, but it's a compromise. I'm completely free Tuesday evening, afternoon, late afternoon.
Well, there's a meeting in here at 6 o'clock on Tuesday.
Because
Already.
Housing and Human Welfare meets.
What about like
at 6.
in the afternoon, 4 o'clock?
Tammy, what's on the agenda for the,
HCC,
yeah,
one thing compromise,
Well, let's,
Yeah, that's what I wanted to,
You didn't get enough last night?
Is
No.
Tuesday the 3 open?
My only thing about Tuesday is like I
Called for
said,
landscape survey.
that's her deadline.
wow, the landscape survey?
Huh?
I know, but
Oh, culture, oh, yeah.
can we budge on this arbitrary deadline?
well,
Or I'm gonna have to take my annual leave
No,
at work.
Rob,
If we can budge
Rob.
this deadline, let's do it.
well, let's
It's-
do
it's-
Monday then. You
it's
said
n-
you could do Monday.
If I take off time at work, I don't take off time at work, if we do it on Tuesday
Yeah,
and try to get movement on this arbitrary deadline.
you know,
Okay,
this deadline
you
for the
can't-
agenda is, many times over the years, has been moved.
Yeah.
Okay, so it's, I don't know how that's set, it must, you know, it may be set on what Jacqueline needs in terms
Used
of
to
getting
be
ready.
Wednesday.
Yeah, it did, and so, you know, sometimes it has to be moved.
I'm free,
Well, we're
So-
only,
free on
six,
Tuesday.
there's another meeting in here at 6 o'clock
On what?
on Tuesday.
October, can't it?
Yeah.
So if we don't get to it, we don't get to it.
So we're talking about Tuesday now?
This
Yeah,
bill was the people
Tuesday-
that came and sat around till midnight.
We do
I know.
Tuesday at 3 o'clock?
Well, that's not
No,
the only
Tuesday at
thing in
4
that
o'clock.
bill.
Huh?
That's not the only thing in
4
that bill.
No,
Okay.
We could do 2 o'clock on Monday. Takia, is that working for you, 4 o'clock on Tuesday?
I'm not buying 2138 No, I'm not.
Love that.
No, I don't.
At 6.
No, housing and
Seven.
development is at 6.
Well,
Maritime
we
Lodge
need
is
to-
at
I
7.
wanna have a
Yeah, but
conversation
housing is here
about
at 6.
the philosophy of the
Oh, that's right, they're on
drafters
there.
about
Housing is in
45
here at 6
foot
o'clock now.
threshold, because clearly they're saying over 45.
So 4 o'clock
needs
on
to be
Tuesday
something
or 2
special.
o'clock on Monday?
And there are
What is
some
it?
real problems with the zoning.
Tuesday would give me more
line
time.
21,
Okay.
Give us more time.
38030 with 21240508, which basically says over 45 feet, you have to rezone, the way I interpret it.
Tuesday at 4 o'clock.
Tuesday at 4?
Tuesday at 4. No, go right ahead, do whatever, just ignore us.
So we're moving it from
Tuesday
Monday?
at 4, and Gary, will you deal with the law department with the agenda,
Yes,
please?
Day.
it's okay. I mean,
So-
I'm telling you, there are times when that deadline just has to be extended,
I am very cognizant of staff,
you know?
okay? And they set deadlines not arbitrarily
Yeah.
for a reason, and so I would respect that.
Right.
So if you're gonna work that out with them, I'm good.
I think we can work it out. Let's go in deference to Rob because, you know, he's got a legitimate reason too that he's got going on. So,
For the livelihood.
yeah, so I think that we can work with the agenda being going out on Wednesday midday or so rather than Tuesday
Okay.
midday.
You've worked it
Thank you.
out? I'm good.
I will work it out. I'll talk to Rich and Jacqueline and we'll work it out. We've got, you know, we've got a limited,
You got through law school?
Yeah,
Couple
right.
of professors.
Yeah,
Come on,
right.
Give me a couple more days.
yeah, right.
Okay,
Always looking
so
for more time.
Tuesday,
Yeah.
all right, anything else for the good of the order? Oh, God, thank you. Meeting's adjourned.
So, are you?